Please, Your Lordship.
Yes.
Lordship, if you may seek Your Lordship's indulgence. Items 1 to 9 and item 18. These matters were ordered to be listed after the judgment of a division bench on the issues raised in this petition. Now, the division bench has passed the judgment. I need to do some work, Your Lordship. I need to do some work so that when I present my arguments on these cases, there is clarity and I can assist Your Lordship. So if these matters can come up on Monday, coming Monday, my Lord.
Coming Monday.
Yes, my Lord.
That is what? Monday will be 23rd, 22nd.
22nd.
You are for the petitioners?
Yes, I'm for the
In all the cases?
Yes, my Lord.
And what about the other side?
They are all here.
Lordship, I am for the state in item 18.
I am for respondents 1, 2, and 3 in items 1 to 9, my lord.
Santiago, you are playing for which party?
NHITCL, my lord.
NHIDC.
Yes, my lord, as well as the union.
As well as the union.
Yeah, Mr. Angami is for the state.
My lord, I'm for the union.
In 18.
Okay.
Okay. What do you say to his request? Next Monday?
My
My lord.
Okay, please, right? Mr. S. Imami, learned counsel for the petitioner, submits that the writ appeal concern has finally been disposed of by the division bench of this court. And since the decision taken in that writ appeal would have some bearing on the present cases, he prays that the matter be taken up on 22nd of June 2026 for consideration. Stop the said prayers not opposed to by the learned counsels appearing for the opposite parties. In view of above, these matters on 22nd of June 2026, item 1 to 9 and 18.
My lord.
Much obliged.
May I please, Your Lordship? My lord, a file of listing of a petitions, compulsory retirement.
Okay,
We filed it on 11/6/26, but reason based on to the registry, it has not been listed. So kindly, my lord may allow the matter to be listed tomorrow.
all right.
Obliged, Your Lordship.
Lordship, in item 11, if I may kindly be permitted a week's time, Lordship, to file my reply. It is under drafting. My client is under period, which is why she was unable to come to Kohima
Yes,
for appending her signature.
all right.
If you can kindly be listed on 23rd.
Item 11.
Yes, my lord.
Please write Mr. Santiago, learned counsel for the petitioner, submits that he may be granted a week's time to file rejoinder affidavit to the affidavit of position filed by the state. Stop Mr. Imti Song, learned additional AG appearing for the state has no objection. In view of above, list on 23rd of June 2026 as paid for.
Deeply obliged, my lord.
Bless your Lordship. Lordship, I'd like to mention item 20. I am for the state here. Your Lordship, I may be allowed 2 weeks' time, Your Lordship, to file my counter.
Okay, counter not yet filed. Mr. Jamil?
Lordship.
Okay,
Please,
Yes.
Mr. Lordship, I'm for respondents 6, 8, and 9, and we have filed our affidavit in opposition.
you have filed.
Yes.
Mr.
Moaim Chen.
Moaim Chen, learned government advocate, appearing for the state, submits that he may be granted
2 weeks' time.
2 weeks' time to file counter affidavit. Madam, your name?
Menoshiano.
Sorry?
Menoshiano.
It's there, it costs this.
Yes, Your Lordship.
Menoshe, no. Learned counsel appearing for respondent numbers 5, 8, and 9,
6, 8, and 9.
or 6, 8, and 9. Submits that counter affidavit has already been filed by the state respondents. Stop the prayer for time for filing counter affidavit. This is not opposed to by Mr. C. Jamil and senior counsel. Appearing for the petitioners. In view of above, list this matter again after 2 weeks. Counter affidavit be filed in the meantime.
Interim may be continued.
Interim order passed earlier shall continue till then. Any rejoinder? Not required.
Yes, we'll be filing a reply.
Okay, petitioner is also at liberty to file rejoinder affidavit in the meantime. Okay.
Yeah, please, my lord.
Yes.
Lordship, I beg to mention item 21.
Ah.
Lordship, I'm for the state responding 1 to 4.
I have received the previous comment, so if 2 weeks' time can be granted, your lordship to file my counter matter.
Yes, respond, petitioners.
Your Lordship, we have received the counter affidavit of respondent number 5.
Lordship,
Okay.
I'm for the respondent number 5 and we have filed affidavit in opposition.
Okay,
We have
okay.
received this morning, so
All right, all right. Mr. N. Nangami, learned government advocate, appearing for the state respondent, submits that he has received the Paraway's comments and prays that he may be given 2 weeks' time to file counter affidavit. Praise the Lord. Stop. Ms. Menacino, learned counsel, appearing for respondent number 5, submits that respondent number 5 has already filed counter affidavit. Stop. Miss, your good name?
Asandi Jamil.
Ms. Asanti Jamil, learned counsel, appears for the petitioner. In view of above, 2 weeks' time is granted to the state for filing the counter affidavit. Liberty is also granted to the petitioner to file rejoinder affidavit, if so advised. List again after 2 weeks.
If you oblige me. Your lordship, there is an interim. I think they have forgotten to mention, your lordship.
Are you sure there's an interim?
Yes.
Okay. Interim order passed early shall continue till the next date of listing.
Oblige, your
All
lord.
right.
May I please, your lordship, I beg to mention item number 16, lordship. This morning I've received the affidavit in opposition filed by the respondent. So kindly allow me 3 weeks' time to file my reply, lordship.
Your good name, please?
Tushi Tumchen.
Mr.
Tushi Tumchen.
Tumchen.
Yes, lordship.
Toshi Tumjen Pongenar, learned counsel for the petitioner, submits that he has just received a copy of the counter affidavit of the state respondents and prays for 2 weeks' time to file the rejoinder affidavit. Praise allowed. List again after 2 weeks. Rejoinder affidavit be filed in the meantime.
Much obliged.
May I please, your lordship, I beg to mention item number 30 on behalf of my senior and newcomer. Lordship, my senior is indisposed, so kindly this matter may be fixed on Thursday.
It's coming Thursday.
Lordship,
Anyone for the?
I'm free, respondent number
Okay,
11.
no objection?
No objection, lordship.
Mr. N. Nangkumar, learned counsel for the petitioners, is said to be indisposed, and a prayer for adjournment has been made on his behalf to the effect that the matter may be adjourned today and be listed again on Thursday. That is the date, what?
18.
18th. The state prayer is not opposed to by the learned counsels appearing for the opposite parties. So in view of above, list the matter again on 18th of June 2026.
Perhaps, my lord. My lord, I beg to mention item number 15. In 15, I have received the affidavits of the respondents. So I may be given at least 3 weeks' time to file my reply to the affidavit filed by the respondents.
How much time?
3 weeks, my
3
lord.
weeks. All right, Mr. Foseko, learned counsel appearing for the petitioners, I miss that. You would like to file which reply affidavit to the affidavit of opposition filed by the respondents, and for which he prays for 3 weeks time. Praise the Lord. List again after 3 weeks. Petitioner to file the rejoinder affidavit in the meantime. All right.
I'll oblige, my lord.
My please, lordship, I beg to mention item number 12.
12.
Yes, lordship.
Yes.
Lordship, I'm appearing on behalf of Kohima, the counsel for petitioner. Lordship, can you bring 2 weeks time?
For?
As the leading counsel is have some personal difficulties today.
Okay, Mr. Fakindra Chabo, learned counsel appearing for the petitioner. He said to have some personal difficulty to appear before the court today. On a prayer made on his behalf by Mr. Tofikedo, give your name by writing. Learned counsel, and not opposed to by the other side. Matter stands adjourned for 2 weeks.
Lordship, I would like to make the same prayer for item number 22 and 31.
22 and 31. These are for orders 22 and 31. See, we'll do one thing. Let the matter be called. We'll pass the order when it reaches. Okay. So no adverse order will be passed. Don't worry. Yes.
Much obliged.
May I please, your lordship? Your lordship, I would like to mention item number 19.
19. Yes.
Your lordship, I'm yet to file affidavit in reply, so I'd like to pray for some more time.
How much time?
I pray that it may be listed after the vacation.
Your good name?
Vizo Nino.
We'll have to keep that in writing, okay?
Yes.
Mr. Additional Learned Counsel appearing for the petitioner submits that she may be granted further time to file the affidavit in reply. So accordingly, when is the vacation? From
27 to
27?
12.
Okay, accordingly, 3 weeks' time is granted for filing the general affidavit as paid for. List again after the NC summer vacation. Yes, call.
For admission, item number 10.
Yeah. Mr. Inti, what is this matter? Oh, this branch manager. Or what? SBI? Branch manager of what bank? SBI, yeah. None appears for the petitioner when the matter is called. List again after 2 weeks.
For admission, item number 13.
Yes.
Lordship by an order dated 7th May 2026, Lordship. Certain directions were issued against the respondents, Union of India as well as the state government.
7 May.
7 May, Lordship.
So. I don't find any 7 May order.
So I have a copy of the order, Lordship.
Okay, somewhat. I got it. Yes, what was the direction?
If your Lordship may kindly come to paragraph 13, Lordship. This matters pertaining to occupation of the petitioner's land by the Assam Rifles, Lordship.
Where? Which place?
Page number,
Which place?
Lordship, it falls under Chumugurima district, Lordship, Kukit Tolong, Lordship.
So?
Now, some directions were issued, Lordship. May I read it? Paragraph 13, Lordship.
Yes.
Therefore, the court is inclined to direct respondents 1 to 4, being instrumentalists of the Union of India, and the respondent numbers 5 to 7, being instrumentalists of the state government, to respond to the following queries of the court. There are 5 queries, Lordship. 1. Whether the land occupied by the Assam Rifles in the present case in relation to the petitioner should be declared illegal and void ab initio, having been taken over without any authority of law from the state government. 2. In view of the admitted possession of 6.61 acres of land, why due to inaction on the part of the state to resurvey the land, the state government should not be directed to pay compensation for the land in the form of rent to the petitioner from 1983 to 1985 and 1986 till date, within a time frame to be fixed by this court, and to recover the same from the occupying authority, that is the Assam Rifles. 3. Why, in view of the inactions on the part of the state respondents and in the Union of India, this court should not fix the rent of the land by taking into account notification dated so and so, as well as the prevailing market value of the land. 4. For the respondents, that is the Union of India and the state respondents, are put to a notice as to why exemplary cost and a direction for payment of interest should not be passed by this court to compensate the petitioner for the financial loss suffered due to non-receipt of the rent for the past 40 years from the Assam Rifles. 5. Why, in the event of non-payment of rent, this court should not issue a direction to the Assam Rifles to vacate and hand over possession of land within the time frame to be fixed by the court.
What is your original prayer?
Lordship, my prayer is for payment of rent and to acquire the land in terms of law.
Acquire the land.
Yes, Lord.
What law is prevalent in the state?
Lordship,
For acquisition?
1965, the State of Nagaland Act, there's 1965 Act, as well as 1894 is also applicable. Land Acquisition Act.
1965?
Nagaland Land Acquisition and Requisition Act, 1965.
65.
Yes, Lord.
And 18, what is that?
1894.
1894 is also prevalent.
Yes, Lordship.
But now we have 2013.
Yes, Lordship, 13.
My prayer is also that, Lordship, as per the latest provision of law, Lordship.
No, that's your prayer, but what is applicable? That's what I'm asking.
Lordship, both are applicable. Lordship, in a recent judgment, Lordship, by the Division Bench of this Honorable Court, a direction was issued to pay the petitioners in terms of the Act of 2013, compensation in terms of the Act of 13, Lordship. That is Writ Appeal 6 and 7 of 2025, Lordship.
In terms of 2013?
2025, Lordship. Yes, in terms of 2013, Lordship.
Then what will happen to that 1965?
Lordship, whichever is more beneficial for the petitioners who should apply, Lordship.
1894 is already repealed.
Lordship.
So there's no question of bringing it back again.
Lordship. By the Act of 13,
We have
Lordship.
to move forward.
Yes, Lordship.
Because what is more beneficial will be, you should be getting that.
Yes, Lordship.
I think what is beneficial is the 2013 Act, 100% solicium and all that,
Lordship, yes, Lordship.
which is not there in the 1890 things. 1890. So after this order, what has happened? Have we,
Lordship, the union, they have also filed an additional affidavit, Lordship, but the state is yet to come up with any instruction as to what steps has been taken by the state. Lordship.
yes,
May I please, Lordship, my lord, in regard to the direction given by this honorable court, my lord. I have received instruction that affidavit is already filed, my lord. Your lordship will kindly see the affidavit filed by the state, my lord.
by the state.
Yes, in the state,
When did you file it? State is respondent number.
5, 6, and 7.
What?
It was filed on 17 March 2026.
567.
Yes, 5, 6, and 7.
1, 2, 3, 4 is there. Then 7 is there. Who is 7?
The deputy commissioner.
Deputy Commissioner, my lord.
So the deputy commissioner has filed separately.
No. It was filed by the 5, 6, and 7 on behalf of 5, 6, and 7. It was
But
filed
it
by,
doesn't say so. It says affidavit of possession filed by respondent number 7.
yes,
Doesn't say on behalf of 5, 6, 7.
yes, by the respondent number 7. My lord, you also may kindly say para 4.
Para 4.
Yes, my lord. May I read, my lord?
No, before that,
Yes, my lord. Here it clearly says that, my lord, your lordship may.
we'll come to that
Yes.
aspect. What I'm asking you now is respondent number 7 alone has filed.
Yes.
He has not said that I'm filing on behalf of 5, 6, and 7.
No.
He said it's filing done by 7 only.
Yes, it was filed by the 7, my lord.
Who is 5 and 6?
Chief Secretary.
And Secretary Revenue, Commissioner Secretary Revenue.
Yes, my lord.
So Deputy Commissioner will file on his own only.
Okay.
I don't think he has filed it on behalf of 5 and 6.
Yes, it was filed by respondent number 7 only, my lord.
So it is the government who has to take the decision. Deputy Commissioner is not the government.
Not you.
5 and 6 will have to do something about it. 7 will be at best, will be the collector, act as a collector. Or
And my respondent number 7, the deputy commissioner, my lord, has conducted survey
Hmm.
and the survey report was submitted on 26/9/2025. Your lordship may kindly see page number 7, my lord.
7.
Yes,
Survey as per what? Whose direction?
my lord, on page number 6, your lordship may kindly see page number 5 and 6. Page number 5.
Hmm.
This letter was received from the Union of India, my lord, from the Assam Rifle, my lord. In para requested the deputy commissioner to conduct a verification, my lord. The lordship may kindly see page number 5.
Yes, 17 June 25.
Yes, and-
Requesting the Deputy Commissioner.
Yes, my lord,
Then-
and survey was conducted. And the survey report is annexed at page number 7, my lord.
Now, who's this, page number 6? Principal STI
Yes.
means,
Land record and survey officer, my lord.
STI means what? Full form of STI.
Training Institute, my lord.
Okay.
So, my lord, direction was given to the district land record survey officer to conduct the verification, and the verification was submitted. So, as per the verification report, my lord, your lordship may kindly see the second paragraph, page number 7. Joint verification was conducted. We have done the spot verification along with the officials from the district administration, paramilitary officials, landowners, and the village council. As per the boundaries shown by the landowners and the officials from the military, an area measuring 5.87 acres at Pibima and 4.36 acre at Kokitolong was found on the ground possession. Therefore, the spot verification report along with trace map and the satellite imaginary maps of the areas are submitted for further perusal and necessary action. So, my lord, as per this affidavit, it clearly says that in the para 4, the
No.
deputy commissioner is saying that
See.
there is no record, my lord.
See, you have just read paragraph, page 7, second paragraph.
Yes.
What does it mean? As per the boundaries shown by the landowners and the officials from the paramilitary, an area measuring 5.87 acres at so-and-so and 4.36 at so-and-so was found on the ground position, means it's occupied.
Presently occupied.
It's occupied.
Yes, by the military man.
Okay.
And my lord, in the affidavit, in the affidavit, it clearly says that there is no record, my lord. Page number 3, your lordship may kindly see the affidavit. Page number 3, para 4. Para 4. In the last line.
Yes.
Further, it is also stated that in the office of the Deputy Commissioner Jumbo-Kidima, there is no record available to show that land compensation or rent premium has been made to any person or the petitioner. Now, this is the possession, my lord. There is no record.
Lordship, on perusal of all this affidavit, Lordship, the direction was issued, the latest direction which was issued. So now the state as well as the unit, they have to come and appear on record. What steps they have taken in order to make the payment, Lordship?
And my lord, this morning I have received the additional affidavit filed by the Unit of India. And in the last page number 18 and 19, it says that this is the latest letter conveyed to the Deputy Commissioner. So, my lord, I may be allowed time to seek instruction in this regard, my lord. Your lordship may kindly see the additional affidavit.
So the assemblable authorities are saying that now tell us how much is to be, what is the assessment,
Yes.
so that we can propose the
Yes, Lord.
payment. This letter was written on January 26, 2026. It's 5 months ago. What has happened now?
I have not received any instruction regarding this, my lord. Kindly allow me time, my lord, to obtain instruction, my lord.
Mr. Yanga, what is that?
Yes.
Why are you sitting behind? You're occupying land?
Yes, Lordship, when it comes to the petition,
Yes,
relevant portion is page 49. This is a type copy.
49.
Yes.
What is there?
Yes, may I read, Lordship? This is dated 12 January 2006. Whereas the government of Nagaland is pleased to reiterate that department, land notification so and so, in connection with the land acquired by the central government departments and agencies by this memorandum so and so, and wherein it was already notified that all the land required by the central government of the union in government or other parties shall be first acquired by the state government. First, it will be acquired by the state government and it will be handed over or released or lent to the central agencies, Lordship.
What is this document?
This is a document, this is a document of the land revenue,
Notification is issued by the state government.
government of land revenue, Department of Land Revenue. So if any land is required by the central government or its agencies, the land has to be first acquired by the state government. Then after that, the state government give it to the central agencies, Lordship.
Then how did you occupy the land? Before acquisition?
Earlier, Lordship, the land was occupied by CRPF. Earlier. That was in the 1988.
So CRPF, you have to explain.
Yes, thereafter CRPF, after that, we came to occupy the
It's
land.
like saying I was
The notification says
But
that.
occupied first, so we came later on.
No, notification says that if land is required, or if the land is already occupied, if the land is already occupied by central agencies, if we need the land, we request, or if the land is already occupied, then the state government will take a survey, and then they will list it out to the central agencies.
So understood that notification is of 2006. This is what is there in the letter in the paper. But what actually is happening is something else.
Yes, we have already written a number of times to state government to do needful to.
Like, where's the letter? Are you saying that you have written recently only?
No, not only recently.
Then,
Where's the
when was it written? It's not that you don't have the means. You have the means, you require the land, you hire it, or you compensate, or you acquire it. Landowners cannot be left like just like that.
By affidavit person unit, starting from page 14, these are all the documents whereby we have requested state government to.
Anyway, these are what bygone issues.
Yes, Lordship.
Right now, let us be concerned with this letter dated 31/1/2026.
Yes, good.
How are you going to react on this? Let us know by the next date.
Yes, my lord.
As soon as the state government, the assess the land, so that we are willing to pay. We have also said that we are willing to pay, but it is the state government that has to assess the land. And after the cutting of the National Highway 29, the land has also reduced. The land that is occupied by us.
When can you get the instruction? Which should be by way of an affidavit, not verbal instruction.
At least 3 weeks, my lord.
3 weeks.
Yes, ma'am.
You take your time, but you must come with something concrete, something concrete. You are Mr.
Itiba home.
Itiba Home. We have to refresh my memory, so I'm sorry, I have to ask your name. Yes. Please write. The attention of this court has been drawn to the order of this court passed on 7/5/2026. More particularly at paragraph 13 of the said order. The same may not be reiterated. As necessary directions have already been recorded. Stop. The grievance of the petitioner, in short, is that where is the land? The land? Your land?
Under Chumugilma district lordship. What will find the facts in the ordered lordship 7/5.
Is that his land has been illegally and forcibly occupied by the security forces, which measures approximately
6.61 acres of land.
which approximately measures 6.61 acres.
Lordship, after the new survey, it is 4.3.
Just a minute. The land is situated at Ukidolong village in the district of Chumekadima. get this in the synopsis, okay? Stop. However, after a survey was done, where was that?
Your Lordship,
Page 6 of the respondent 7's affidavit, Lordship, page 6 and 7.
Survey. There are two areas, isn't it? 5.87 and 4.3.
Yes, Lordship, we're concerned with 4.36, Lordship.
After a survey was done recently, by the Office of the Principal Survey Training Institute, the total area of land occupied at Kuki Dolong was found to be 4.36 acres. And a report to that effect was submitted by the Principal Survey Training Institute to the Deputy Commissioner Chumukodima, Nagaland. The Gauhati Lanet CGC submits that after the survey was done, the Assam Rifle authorities have written to the Deputy Commissioner Chumukodima District on 31/1/2026 asking the state authority to provide the annual lease rent amount for the land occupied at Kuki Dolong, so that the matter can be processed for payment of rental compensation, etc., to the landowners concerned. So he submits that since there's no response as on date, the Assam Rifle authorities are not in a position to proceed further. So up to this submission, Mr. E. Thibapon, learned government advocate, submits that he may be given some time to receive instructions in this regard and get back to the court with the updates. To stop for this, the learned government advocate prays for 3 weeks' time. Stop considering the prayer. Further 3 weeks' time is granted to the government advocate to receive the instructions. The instructions to be received should be filed in the form of an affidavit. List the matter again on so and so. We'll have it after the vacation.
Lordship.
20th of July, 20.
Lordship.
Okay.
Much.
Lordship.
For admission, item number 14.
Lordship, this
May I please, Lordship?
Yes.
My lord, here I have received instruction that respondent number 61 to file affidavit. So kindly allow me 3 weeks time, madam. 7 has already filed, madam.
Okay.
Otherwise, Lordship, similar orders and actions may be issued even to the respondents, Lordship, like the earlier case.
This is also same thing.
Lordship, yes. I'll take your lordship just to one document, page 69, lordship.
Where is that?
Page 69 of the read petition. Lordship. This is a communication dated 15 November 2011. It was written to the Director General Assam Rifles, lordship. Unauthorized occupation of land, an area measuring so and so at Tuensang town belonging to the Sikh Health of Tuensang village by the Assam Rifles.
2011, then
Yes,
what happened?
Lordship, there were several communications made, lordship, and even in page number 75, lordship. Page 75. This is 2018. Submission of land occupied by the paramilitary forces in Nagaland. Page 76 is about a report. It's written by the government to the Deputy Commissioner, lordship.
No, these are 11, 2018 and all that. What
Lordship,
has happened as of now?
No steps has been taken neither by the central government nor the state government, lordship. And it is an admitted position, lordship. They are an occupation of the land without following any due process of law, lordship.
And how do you say, on what basis do you say that it is your land?
Lordship, it is admitted fact. In fact, even the
Don't say that everybody knows like that.
The district administration as well as the village functionaries, they have already admitted.
Admitted.
Yes, lordship.
But there must be a basis of.
And the Deputy Commissioner has clearly stated in his letter, which I have to refer to it, page number 69. They are occupying since 1958, lordship.
Occupation is one thing, of course, but your ownership of the land, how do you say it belongs to you?
Lordship, the land holding system in the state is different, lordship. The land belongs to the people, lordship. Now, lordship, unless the state government or the central government, they go through the process of acquisition, lordship. The land still belongs to us, lordship.
Who are the petitioners?
Lordship, they are the members of Sikh Health. They all belong to the Sikh Health village of Tuensang village, lordship. Sikh Health of Tuensang village.
They are the villagers.
Yes, lordship. They are all together 84 petitioners, lordship. They are all the landowners.
No, how do you say it is your land and how is the boundary demarcated?
Lordship, I'll take your lordship to a document, lordship, in page 780, lordship.
Page?
80, lordship.
80, yes.
80, lordship. This is a document of the Assam Rifles, lordship. The third column, lordship, Tuensang district.
Page 80.
80, lordship.
Third column means? Yes.
Tuensang district, Tuensang headquarter, in the area of 288.01 acres of land acquired in the year 1962. Now, they in all the communications, they are using the term acquired lordship. Whereas in their record, the state as well as the central government, they have filed their affidavit. Nowhere they have produced any record to show that they have acquired a land at any point of time, lordship.
See, again, you are putting the same question. They have acquired the land, they have occupied the land.
Occupied the land, lordship.
I'm asking you, how do you say that it is your land? On what basis are you saying that this is my land or this belongs to the villagers? Lordship, there is no document as such. No document, no pass, nothing like that.
Lordship, if you have a lot, page 41. Page 41. This is a land ownership certificate issued by the Tuensang village.
By whom?
Tuensang village, lordship. Village council of Tuensang.
When was
Land
it
ownership certificate, page 41.
When was it issued?
Lordship, there's no date. But the village council has already signed this document, Lordship, and this
Without
proves.
date. Without date.
But this fact is not disputed, Lordship,
You're
because
submitting before a court of law. You have to be precise. The document is undated.
unfortunately, Lordship,
what
the,
is
the
the-
document issued.
Your basic standard is that it is admitted. It is not disputed. It is our land. But
And this certificate, Lordship, because the land holding system, Lordship, in the state of Nagaland belongs to it can belong to any individual or held, or it can be villaged or a joint property, Lordship. So what has happened, Lordship, the village council of that particular village is the authority, the competent authority to issue a certificate certifying that the landowners, Mr. So and so is the landowner of that particular land. Because they normally in the district of Trainson, they don't issue pata, Lordship. So it is the only document that can certify that the individual is a landowner.
But at least some date should have been there.
Exactly, I agree, Lordship. But that doesn't necessarily mean that I'm not a landowner. It's just because the deed is missing, Lordship.
And the schedule of land also is just saying that this land reserved forest, DC residence. This is what.
All along, Lordship, in all the communications, Lordship.
You-
In fact, the Deputy Commissioner has admitted survey has been conducted at that relevant point of time. Just that no steps from the end of the state government or the central government has initiated. Otherwise, the land is not disputed, Lordship. This is the certificate issued, Lordship.
Okay, now what is the current position?
They have to pay land. And if they want to continue occupying the land, Lordship, they have to acquire in terms of law.
Then why have you come now? They started occupation when?
Lordship, 1957, Lordship.
1957.
Yes,
And you
Lordship.
filed writ petition in 2025.
Lordship, there were representations submitted, Lordship. But there are also cases where after 4 or 5 decades, Lordship, the Honorable Apex Court in the cases of Sukdat Ratha or Vidya Devi's cases, Lordship, it was a delay of more than 6, 7 decades, Lordship. And directions were issued by Honorable Apex Court to pay compensation, accord the land in terms of law. My right under 300A is infringed.
My lord, here respondent number 6 want to file the affidavit because this is the
Number 6.
number 6 is the land revenue department. Yes, and their affidavit is very much requirement.
Who has filed so far?
Respondent number 7, DC.
What does he say? Survey has been done.
Yes, my lord.
How much is occupied?
My lord, this survey was done in the year. My lord, in the affidavit, it says that as regard to the land in question, my lord, only 90,000 was paid to the petitioner from the state fund, my lord, not from the Union of India.
When?
Your lordship, mechanically, para 5, it was paid.
Para 5 of what?
Affidavit filed by the respondent number 7. Para 5, it says that in the year 1957, the Assam Rifles occupied the land of petitioner on payment of rupees 90,000 as temporary occupation fee. The said amount was paid from the state fund and not from the central fund. Furthermore, it is apparent from the STO Tunsang letter dated 25/4/2012 that 239.5 acres of land was considered to have been leased out to the Assam Rifles from 1957 for a period of 50 years, subject to renewal as clarified by the Deputy Commissioner, Tunsang District. Thus, the continued occupation beyond the lease period is subject to the renewal and the lawful authorization manner.
It was paid to whom?
To the petitioner, my lord. From the state fund. It was paid from the state fund, my lord.
petitioner means there are 84 of them
Yes, my lord.
and they are
In claiming rule.
they are identified as what? Sikh Hill Village.
Your lordship, may kindly see page 6. Page 6 of my affidavit, my lord. Annexure A. Para 1. Only 239.5 acres of land is under actual occupation by the 8th Assam Rifle at Tunsang, as per the latest survey conducted in 1992. The compensation of rupees 90,000 was paid to the landowner from state fund, and the earnest while NIFA for 239.5 acres of land are now found after resurvey and not from central government. Therefore, the compensation paid by the state government is now required to be recompensated to state fund before land it is processed for signature.
This 90,000 was paid by the NIFA, not these agencies. Before the state.
Which year was that? Payment was done in 1957. Is it?
57, 58, 59.
So what is this survey done after this? 1990, this is 1997.
Yes, my lord.
239.5 acres of land.
Yes.
Mr. Mohajami, what about your claim? Area of the land?
Lordship, my
It covers how many, how big?
289, Lordship.
289 acres.
289 acres, Lordship.
Here it says 239.5 acres. Please write. The claim of the petitioners is that their land measuring 289 acres of land at Tuensang is occupied by the Assam Rifles without any compensation. Post of the affidavit in opposition of respondent number 7, bracket, Deputy Commissioner of where? Of which district?
Tunsang, my lord.
Deputy Commissioner, Tuensang District. At annexure A series of the affidavit goes to show that the subdivisional officer, bracket civil, had written to the commandant of the 8 Assam Rifles on, what is the date?
18 August 1997.
On 18th August 1997, stating that only 239.5 acres of land is under actual occupation by the 8 Assam Rifles at Tuensang, as per the latest survey conducted in 1992. Stop. A sum of rupees 90,000 was paid to the landowner from state fund under the erstwhile NEFA as compensation. Stop. The compensation paid by the state government is therefore now required to be processed again before land deed is processed for signature. Stop. The said document would go to show that some amount of compensation was paid to the landowners. Where is that 50 years thing? Somewhere you've written 50 years. Paragraph 5. This concept of 50 years, from where has it come?
Years.
Stop. At paragraph number 5 of the same affidavit, it is stated that
My lord, page number 8, para 6. The 50 years is written at para 6, my lord.
it is stated that land was leased out to the Assam Rifles from 1957 for a period of 50 years, subject to renewal, as clarified by the Deputy Commissioner to Assam District. So therefore, continued occupation beyond the lease period is subject to renewal and required lawful authorization. Next para, considering the above stand, the Revenue Department, is it?
Yes, my lord. Response number 6.
The Revenue Department, right, as respondent number 6 in the writ petition, is required to make this shall be required to clarify the
May I please, lordship, my lord, sorry for interruption, my lord. Your lordship, may kindly see page number 9, para 9 and 10 of the affidavit, my lord. Para 9, it says that subject land is considered to have leased out for a period of 50 years, effective from 1957, and the occupation by AR is an admitted fact. The period had been expired and ownership of land is returned to the government of Nagaland unconditionally. The state government also acknowledged the payment of rupees 90,000 only as a compensation for 50 years. The Assam Rifle Authority not initiating for renewable extension as required by the law of the land signifies that the subject land is no longer required by it. Para 10, the government of Nagaland reiterate request to pay a sum of rupees 17 crore 5 lakhs 25,300 only. In receipt of assurance, government will publish necessary notification to start process of leasing out land at Tunsang for another 49 years in favor of the President of India. This letter was issued on 25 April 2012.
Lordship may also kindly consider Roman 7, Lordship. Of the same
It
document.
is self-explanatory that the land has neither been legally acquired under the Land Acquisition Act 1894 and Nagaland Land Acquisition Act 1965, nor the state as well as the Assam Rifle has record thereof. After the survey done on 1992, this letter was issued to the Assam Rifle letter.
So this is written by the Deputy Commissioner. Correct?
Yes, Lordship.
Now, what is the reply from the DGR?
There is no reply, my lord. So, my lord, now regarding the acquisition of land, that respondent number 6 will justify, my lord. Yes, kindly give time to file affidavit on behalf of respondent number 6.
We'll grant you time definitely, but these queries have been raised by this district
Yes, my lord.
district deputy commissioner.
In the April 12th, Lordship.
Yes,
Should it not be routed through the government, in the revenue department?
yes. Directly within.
It is written directly to the DGR. What is the channel? Mr. Chipafo, is this how letters are written? What about the commissioner, secretary, chief secretary? It is not routed to them.
It should be routed to the.
The commissioner on their own, they cannot write like that.
Yes, my lord.
Similarly, even the Assam Rifles, the DGR, they'll function through the Home Ministry. Administratively through the Home Ministry, command control through the Army headquarters. That is the channel. Here, DC has written directly to the DGR saying that this is what we are doing. Gauhati has filed some affidavit.
I filed some affidavit, Lordship, as per my affidavit, there's no mention of the prohibition status referred to the government.
Where is your affidavit? 1, 2, 3, 4.
1, 2, 3, 4, Lordship. And Lordship, I have not received the affidavit filed with state government also.
Of respondent number 7, you have not received.
Mr.
Mr. Thiba, you are also representing 7.
Yes, my lord.
Give him a copy.
I think I've already served. I'll serve, my lord.
What is the last line?
No question.
Before that.
Another bit to me.
Stated that land was out of the law. How to get
Okay, questions? Nila ko bilhin tao. Allegations of progress course even the
Some para considering you can't not required.
By problem.
6.
We 6.
Let me.
See.
Next para, it is also seen that the Deputy Commissioner to Ensang District has also written to the Director General of Assam Rifles on 25/4/2012. stating that the state government will publish necessary notification to start the process of leasing out land at Twensang for another 49 years in favor of the President of India, subject to payment of rupees 170525,300. So the said communication is annexed as Annexure B to the affidavit of respondent number 7. Next para, in view of above, the Commissioner and Secretary, Land Revenue Settlement Department, Government of Nagaland, will have to clarify as to what process has been undertaken to make such an assessment for renewal of the lease of the land at Twensang. Mr. E. Tivaform, learned government advocate, appears for the respondent number 6 and prays for
3 weeks time, my lord.
3 weeks time to file the affidavit. Prayers aloud. List again.
Same date, my lord.
Huh?
Same date.
Same date is?
Yes.
What was the date?
20.
List again on 20 July 2026.
Obligation. Much obligation.
For admission, item number 17.
Yes.
Yes, Lordship. This matter come up for admission hearing. Lordship is a short matter. The petitioner is praying for regularization of her service just for pensioner benefits. Lordship, petitioner served the department for more than 24 years as work charge. However, Lordship, after utilizing her service for 24 years by the department, she was released without any pensioner benefits.
You are working as what?
Workshop schedule, Lordship, Mali. Lordship, may I take a Lordship to the documents? She may kindly come to page appointment of the Lordship, page 16.
16.
16th. 17 is the type copy, Lordship. This is order dated 22/4/1998.
Your initial appointment.
Yes, Lordship. Thereafter, Lordship, her service was extended from time to time. And while working as such, Lordship, may kindly come to page 25. Lordship, page 26. This is the release order, Lordship. Shrimati Suinsu Kalasi casual under establishment of the undersigned is hereby released from the government service with effect from 30/11/2022 on attaining 60 years of subordination age or on 1/12/2022. Lordship, all along petitioner service was treated as regular employee, Lordship. Service book maintained, seniority also maintained, and periodical agreement was also granted during her casual service, Lordship. And Lordship, Lordship knows in the state of Nagaland, we have office memorandums which provides for regularization of work charge casual employees. Here in this case, Lordship, I've enclosed two office memorandum issued by the state government. One is Office Memorandum of 17/3/2015, which provides for regularization of work charge and casual employees who have attained 30 years of service. 30 years.
You have 24.
I'm not covered by that notification of 2015. However, Lordship, there is another Office Memorandum of 2004, which provides for regularization of work charge employees and casuals on 50/50 basis. As per the seniority
Where's that?
position of the department, Lordship. Lordship, may kindly come to page 34. My case is covered by this office memorandum, not by the latest memorandum of 2015.
Yes, read. What does it say?
Yes, Lordship. This is office memorandum dated 22/9/2004. Subject: policy and scheme for regularization of service of work charge employees. There are large numbers of work charge employees in the various departments. Many of those employees have been serving continuously for many years. They have been representing to the government for regularization of their service. Some departments have been regularizing the service of work charge employees from time to time against the available vacancies. However, no transparent and rational policy and graded is discernible in the process of regularization of the service of work charge employees. Therefore, in order to examine the issue of regularization of the work charge employees in various departments, the state government set up a committee under the chairmanship of Shri so. On the basis of the recommendation of the Committee for Regularization of Work Charge Employees in the state, the government hereby adopts the following policy and scheme for regularization of the service of work charge employees serving under various departments of the state governments. 1. Each department having work charge employees should maintain a list of work charge employees and various categories in order of their length of service. Regularization of work charge employees will be done against available regular vacancies. 50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees, and the remaining 50% will be filled up as per the normal rules of recruitment. 4. Work charge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department, for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior-most work charge employees in the relevant category will be regularized subject to her fitness for the vacant post. 5. In case no work charge employees is found suitable for regularization in terms of the above clause 4, the department will obtain clearance of being near department before making any fresh appointment against the quota reserved for the work charge employees, explaining the circumstances for not being able to fill up the vacancies through the regularization of work charge employees. No each part would apply in case for regularization if work charge employees is below the subordination age. 7. Regularized work charge employees will be entitled to count and fall their continuous work charge service towards pension benefit. Those departments which have not approached the Nagaland Work Charge and Casual Employees Commission should do so immediately to get the optimum strength of work charge employees fixed for their department. They should take all possible measures, including pursuing BRE's options vigorously to bring down the strength of work charge employees to the level recommended by the Commission. 9th, adequate provision for payment of work charge employees should be made and the budget and regular monthly payment of work charge, which is ensured. All work charge components should be pumped. That is not relevant, Lordship. So, Lordship, my case for regularization governs by this OM. Not by OM up to
By
2015.
which provision in particular? Which part?
No, Lordship, this office memorandum provides for regularization of 50% of the regular vacancies for work charge, Lordship. So during my 24 years, Lordship, I've submitted representations. I approached the authorities for regularization of my service. However, Lordship, without considering my case of for regularization in terms of the policy adopted by the state government, I was released without any pensionary benefits. And aggrieved by the action of the authorities, Lordship, I have submitted a representation. And my representation was rejected by the ambient order on two grounds. Firstly, the reason given in the ambient order is that my case doesn't come under 2015 office memorandum because I've not completed 30 years. I'm not claiming my regularization under that OM, Lordship. That is my specific bleeding in my writ petition.
You cannot claim also. You don't have 30 years.
That is the reason why, Lordship.
Even if you want to claim, you
That is not my bladed case,
You don't have 30 years.
Lordship.
But if you want to claim under this 2004, you should have claimed while you were in service, not after your retirement.
Yes, Lordship.
You were superannuated in the year.
Bruce, no, please, on several occasions, I've made a specific statement in my writ petition.
No, where is that? Approaching several times is not, it doesn't solve the problem.
Yes.
You should have come before the court. And see, office memorandum of 2004 is there, no doubt. But this also doesn't say, guarantee you that you should be regularized. It says that 50% of the regular vacancies of similar nature arising in a year will be reserved for
Yes.
work charge. So whether there was any vacancy during those times.
Lordship, the petitioner is a fourth grade in Louis, Mali, Lordship. And when there is a policy adopted by the state government, it is the department to adhere to the policies, Lordship. Lordship, paragraph 13, Lordship. My statement, Lordship. That the petitioner begs to state that during her service period, the petitioner has several occasions approached the authorities verbally as well as by submitting representations for regularization of her service in terms of the policy evolved by the government, which was not considered. The responding authorities, however, after releasing the petitioner from service without regularization, are now taking a stand that the petitioner cannot be regularized retrospectively in terms of the office memorandum dated 22/9/2004. Such an action of the responding authorities is totally arbitrary, discriminatory, and may not be accepted by this honorable court. Lordship, may kindly come to ambient order. Page 30, Lordship. Lordship, this is the letter dated 18 June 2025. Why I'm referring this, Lordship, the state government, by filing affidavit of opposition, raised an objection that the petitioner was released from service in the year 2022. However, the writ petition was filed only in the year 2025. The Lordship, may kindly say the ambient order is at page 30, dated as 18 June 2025, and I filed the writ petition in the month of September 2025. Oh, Lordship, there is no delay and such, deliberate delay in natures. May I read, Lordship? To the Chief Engineer, Water Resources Department, Nagaland, Kohima. Matters relating to regularization of Shirimati Suinso, retired Kalasi casual for the purpose of pension benefits. And in writing reference to your letter number Suinso dated 26 March 2025, and on the subject stated above, I am directed to convey herewith the views and comments of BNR Department, Organizing Method Branch, right here, Suinso dated 17/6/2025 as follows. Since Miyadunu Kalasi, retired, had served for 24 years of continuous service. Prior to retirement with effect from 1/12/2022. She therefore is not eligible to be regularized in terms of the OM dated 17/3/2015, nor can be regularized retrospectively in terms of OM dated 22/9/2024. I am not claiming regularization under OM of 2015, Lordship, because I have not completed 30 years. However, Lordship, the state respondent authorities ought to have considered my case in terms of the policy adopted in the year 2004, which was not considered. They ought to have considered, Lordship, since there is a clear-cut policy adopted by the state respondents for regularization of book session rules. Therefore, Lordship, my case, my simple, short case is, Lordship, I worked for 24 years in the department and releasing my service without any pensioner benefits is violation of Article 14 of the Constitution of India. And Lordship, I just would like to refer to judgments. And there is, I leave it to Lordship, to judgment only. First, Lordship, 1997, 2 GLD 209. This is a short judgment, Lordship. I'm reading from paragraph 1, Lordship. Mr. Lordship, got it?
Yes.
Paragraph 1. This two writ appeals are directed against the judgment and order dated 21/2/1995, passed by the learned single judge in civil roll number so and civil roll number so. And this two writ appeals, common question of law and facts has been reached, and as such, they are being disposed of by this common order. We have heard so, learned counsel for the appellants, as well as Mr. Suiso, learned counsel for the respondent at length. The facts given raised to the filing of this present appeal may be summarily decided. The writ petitioner and civil roll number so was appointed as casual artist grade 2 in the Department of Drama Unit of Public City, Department by order dated so 1967. Thereafter, by order dated 30 August 1969, he was appointed artist grade 2 from the order dated 1/12/1975 at election so, it clearly appeared that under recommendation of the DVC held on 27/11/1975, additional list grade 1 artist has been prepared in order of merit, and the set list in the name of the petitioner appeared as serial number 1. By another order dated so, election so, it appears that on the recommendation of the screening committee, under the terms of the conditions laid down in the contract and on his acceptance of the terms and conditions of the contract, the writ petitioner was again appointed as artist grade 1 with usual allowances as permissible under the rules. Petitioner in civil roll number so was appointed as casual artist grade 2 in the Department so Public City, Government of Manipur at a consolidated fee of rupees so by order dated so. By another order dated 26/10/1966, he was appointed as artist grade 1. Thereafter, by another order dated 1st December 1975, on the recommendation of the DBC meeting held on so, the gradation list of the artist grade 1 has been prepared in order of merit, and the name of the petitioner appeared as serial number 4 of the gradation list of grade 1 artists. Paragraph 5. The aforesaid two writ petitioners continued in the post from 30/11/1967 and 21/9/1965. Respectively, till their services were terminated on attaining the age of sovereign nation with effect from 28/2/1995 and 28/2/1994 by order dated 31/7/1995. By the time their service were terminated on attaining the age of subordination, the petitioner in civil roll number so had both in about 28 years of service, and petitioner in civil number so both in about 29 years of service as grade 1 artist. Petitioner filed the opposite civil rule with Breyer and Alia to regularize the service of artist grade 1 in the Directorate of Information and Public Relation Manipur. While issuing a roll, this court on 2890, the petitioner directed the respondent not to oust the petitioner from the bonds they are holding. The learned single judge, after hearing the parties, disposed of the petition by an order dated 21/2/1995, with the direction to regularize the service of two petitioners within a period of 2 months from the date of this order. The learned single judge further directed that their services shall be regularized so as to enable them to receive pension and other related benefits. Being aggrieved, the present two appeals have been preferred by the state. Verse 7. Three conditions have been urged before us by Shri So. Number A, petitioner respondents has not approached the court with a clear hand inasmuch as that they were serving on contract agreement has not been disclosed in the writ petition, and as such, the petition is liable to be dismissed for suppressing offense. B, that the petitioner are bound by their own agreement and having knowingly accepted the contract amendment and the terms and conditions laid out thereunder, they are stopped from claiming the regularization of their service. C, the petitioner services were appointed on contract on the basis of the cabinet decision and its meeting held on so. Number 8. In this condition, I'm skipping paragraph 8, Lordship. This is a submission. Paragraph 9, Lordship.
Yes, read.
Paragraph 9, Lordship. Unmaintainability of the writ petition, learned counsel for the appellant has invited our attention to the decision of the Supreme Court and so. And others, ER 1983 AC 622, wherein the apex court had deprecated the practice of making false representation of obtaining relief. Reliance has also been placed in so case. ER 1991 AC 1926, where apex court deprecated the practice of submission of material facts. Well, it is true that the litigant runs a high risk when they obtain relief by submission of facts. In the instant case, disclosure of fact that the petitioner were on contract service would make no difference in view of the order that we propose to pass. Therefore, a process decision is no help to the appellant case. Let us accept the writ petitioners were on contract service, but the fact remains that they are allowed to work for 28 years and 29 years respectively till they are retired on attaining the age of subordination by order dated 31/7/1995. It is in this situation we are examining the case from another angle. The order dated 31/7/1995 retiring the petitioner's respondent is extracted. I'm not reading the order, Lordship. The period of your employment from the date of termination till date will be treated as a period of re-employment on contract basis. You will be entitled to the excruciating rigidity as described in terms of the contract appointment. This is the order that has been quoted, Lordship. Paragraph 11, Lordship. Paragraph 11. We are being disturbed that the petitioner were compelled to go on subordination after boarding 28 and 29 years of service, respectively, without any pensionary and other related benefits. And a welfare state like ours, committed to a socialistic burden of society, it is unconscionable that the employer compels the employee to go on retirement without any related benefits after boarding in 28 and 29 years of service on the verdict of contract service. It will be hit by equality clause as enshrined under Article 14 of the Constitution of India. The writ petitioner respondents have spent entire youthful life to the service of the state, rendering reliable service to the state as an artist. It will be too cruel to allow them to go empty-handed when they are aged, old, and infirm and incapable of earning by themselves. It is common knowledge that a government servant work for future security. The argument that the writ petitioner accepted the appointment with full knowledge of the terms and conditions laid down and in contract, and therefore your service cannot be regularized and they are not entitled to pension and other retail benefits would amount to exploitation of labor. Maybe the petitioner have knowing fully well the terms and conditions of the contract accepted the employment because of the compelling circumstances. The state being a model employer are not permitted to use method of exploitation against the weaker section of the bill. Part 12, Lordship. We unequivocally of the view that the terms contract appointment must be terminated at some stage of your service. But if contract appointment continued uninterruptedly till the age of sovereignty, as is happened in the case at hand, the character of the contract appointment automatically changes and the employees has to be treated under the normal government service rules, entitling them to pensionable benefits. In the instant case, the stand taken by the Belen government that the respondents were on contract service and therefore even if they retired on attaining the age of sovereignty, they will not be entitled to pension and other their benefits is unacceptable. If they are on contract service, their service could have been terminated when they are still youthful and they could have gainfully employed in some other vacation. But then after using their entire service, drain out their energy and when they are aged, old and infirm and incapable of functioning, allowing them to go empty-handed is an invasion of mandate of Article 14 and 21. Right to live has been interpreted as a right to live with dignity. Unless citizens have means of sustenance, right to live with dignity will have no meaning. The contention of the Learned Council for the Abilene are therefore rejected as untenable in law. Since we have rejected the condition of the Abilene as aforesaid, we need not go to the argument advanced by so and so, so and so. For the reason aforesaid, there is no merit in this appeal, and they are accordingly dismissed, however, without cause. So, Lordship, the facts of the Brain case and the facts and the judgment which I've referred to are similar. The respondent authorities utilize my entire service and now releasing after undertaking the age of sovereignty. They are coming with a blade that my service cannot be regularized under the OM of 2015. Which is directly contrary to the judgment which I referred to. And the second judgment, Lordship, 2019 then SEC, 516. I'm referring to paragraph 3, 3 paragraphs only, Lordship. Paragraph 30, 31, and 36. Paragraph 30 starts from page 540.
Yes.
I'm reading paragraph 30, Lordship. We are not embraced by the opposite submissions. The appointment of the work charge employees in question had been met on monthly salary and they were required to cross the FCC bar also. However, their services are qualitatively different from regular employees. No materials indicating qualitative difference has been pointed out except making bold statement. The appointment was not made for a big particular project, which is the basic concept of the work charge employees. Rather, the very concept of work charge employees has been misused by offering the employment on exploitative terms for the works, which is regular and biennial in nature. The work charge employees have been subjected to transfer from one place to another, like regular employees as apparent from the documents placed on record. And so case, so the appellants were also allowed to cross efficiency bar after 8 years of continuous service, even during the period of work charge service. Narayan Dot Sharma, the appellant, was appointed as a work charge employee as CSU with effect from 15/9/1978. Women used to be made monthly, but the appointment was made on the pay scale of Rupees. Initially, he was appointed in the year 1978 and a fixed monthly salary of Rupees per month. They were allowed to cruise efficiency bar also, as the benefit of pay scale was granted to them during the period they served as a work charge employees. They served for 3 to 4 decades and later on service have been regularized time to time by different orders. However, the service of some of the appellants and few appellants have not been regularized even though they had served for several decades and ultimately reached the age of sovereignty.
Are you done? Paragraph 30,
Yes, and paragraph
31, 36 also.
31 and 36.
I'll just rise for 5 minutes and come back. I'll come back in 5 minutes. Yes.
Yes, may I continue from paragraph 31? Paragraph 31, Lordship.
Yes, please read.
In the opposite facts and circumstances, it was unfair on part of the state government and its official to take work from the employees on the work charge basis. They ought to have ensured to appointment on regular basis. The taking of work on a work charge basis for long amounts to adopting the exploitatives. Later on, too, their services have been regularized. However, the period spent by them in the work charge establishment has not been counted towards the qualifying service. Thus, they have not only been deprived of their due emoluments during the period they serve as on less salary and work charge establishment, but have also been deprived of counting of merit for pensionary benefits, as if no service had been rendered by them. The state has been benefited by the service rendered by them in the heydays of their life, less salary in work charge establishment. Paragraph 36. There are some of the employees who have not been regularized in spite of having rendered the service for 30 to 40 or more years, whereas they have been subordinated. As they have work and work charge establishment, not against any particular project, their services ought to have been regularized under the government instruction and even as per the decision of this court and so. This court, in the said decision, has laid down that in case service have been rendered for more than 10 years without the cover of the court's order as one-time measure, the service be regularized of such employees. And the facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regulate them on term for consideration of regularization as others have been regularized. We direct that your service be treated as a regular one. However, it is made clear that you shall not be entitled to claiming any dues or differences in which is had they been continued in service regularly before attaining the age of subordination. They shall be entitled to receive the pension as if they have retired from the regular establishment and services rendered by them right from the day they entered the work charge establishment shall be counted as qualifying service for the purpose of pension. Lordship, similar subject matter issue has been decided by this court, Lordship. The facts in that case is slight difference because the petitioner in that case was released from service after attaining the age of length of service of 35 years, Lordship. And the learned single judge have directed the respondents to recognize her service for pensioner benefits only, a case which writ appeal was filed and the appellate court upheld the single judgment and order.
What was the direction of the learned single judge?
To regularize the service of the petitioner.
And on what basis?
Lordship, direction is page. Lordship. Direction was based on the principle laid down by the Honorable Apex Court. Lordship, we kindly come to paragraph 4. of the judgment of the single judge, Lordship. Judgment rendered in Dalsi Bhai, Ranji Bhai Patel also reflected here in this judgment, Lordship.
What was the facts in this case? Already superannuated.
Yes,
After superannuation.
after attaining the length of 35 years of service.
So 35 years means you could have been covered by OM, that OM.
That the petitioner in this petition, Lordship, he was not come under this OM because he was not enjoying base scale. Because OM of 2025 provides for regularization of those workers and employees after attaining the 30 years of length of service who are enjoying base scale.
Enjoying base scale. The OM is of 2025.
Yes, Lordship.
2025.
Yes, 17/3/2020.
Okay, but this judgment is rendered in 2000, which year?
2021.
Date of judgment is 2022. So OM was not there that time.
Lordship?
OM was not available that time.
It's 2015, Lordship.
Or 2015. You said 2025.
No, Lordship, 2015.
2015.
Yes.
But that OM has not been referred here.
In the appellate court's judgment, Lordship, it is reflected.
No, in the single judge's order. Writ petition, OM is not reflected. Only Supreme Court.
Yes, Lordship.
Tulsi Bhai.
Yes.
OM of 2015 is also reflected here at paragraph 5. It is there.
Yes, 17/3/2025.
17/3/25.
Yes.
30 years. Pay scale. Then, so I think that's a distinction here. So writ petition was disposed of in terms of
Not in terms of the OM of 2015, in terms of the judgment rendered by the apex court. And this judgment was appealed by the appellate court, Lordship.
so all those judgments which you have read has been also cited here.
Lordship, yes.
97 GLT and all that.
Yes. GLT, I'm not sure, Lordship. However, 2019, that Brim Singh judgment has been cited here, Lordship. In the order passed by the appellate court, Lordship.
But the facts were very clear in that case, you see, because representation was filed while in service
Lordship.
on 7/9/2015 for operation of his salary and from fixed pay to scale pay. Okay, this is scale pay. 35 years, but not in scale pay.
No.
Oh, that is the difference. That is why that OM is not.
Yes, Lordship.
Okay.
So by Lordship, humble submission, your Lordship, is that my case is covered by the decision rendered by the Honorable Apex Court as well as the decision by the Honorable Court. I'm not claiming recolorization in terms of OM of 2015, Lordship. Lordship, we can come to few paragraphs of my writ petition, Lordship. Paragraph 10, Lordship. Paragraph 10, my petition, page 9. I'm referring to three paragraphs, 10, 11, and 12. Page 9. Paragraph 10. That the office memorandum dated 17/3/2015 mentioned in the ambient order provides for regularization of workers and casual employees who are enjoying scale B and who have completed 30 years by conversion of your boss into regular one. It is not a claim of the petitioner to regularize her service under the said office memorandum. inasmuch as the petitioner case doesn't come under the said office memorandum. The claim of the petitioner is for regulation of a service for the purpose of pensionary benefit in terms of the law laid down by the apex court as well as by this honorable court. Therefore, the reason given in the impugn later dated 15/6/2025 that the petitioner is not eligible to be regularized in terms of office memorandum dated 17/3/2015 is totally misconceived. 11. That as regards the other grounds in denying the regulation of the petition service that the petitioner cannot be regularized retrospectively. In terms of the office memorandum dated 22/9/2004, it is stated herein that once the government evolved the policy for regularization, it is incumbent on the part of the state respondents as employer to adhere to such office memorandum by regularizing the eligible employees. However, failure on the part to follow the office memorandum and taking the blade at this stage of the retirement that the petitioner cannot be retrospectively regularized under the office memorandum of 29/2004 is nothing but trying to cover up their discriminatory and illegal action. As such, it is a fact case where an inference of this honorable court is called for. Your Lordship, paragraph 12. That the petitioner beg to state that the petitioner served the department with sincerity and devotion for more than 24 years. In the year 2019, verification of work charge and individual employees have been ordered by the government to all the departments. In respect of the Water Resources Department, Dimapur Division, such verification was conducted by the Deputy Commissioner, Dimapur, and draft was submitted by the Deputy Commissioner by letter dated 8/11/19. In the said verification list, the petitioner name is also figured as serial number 11 as verified employee. More by order number so dated 17 January 2022. The article agreement was granted to petitioner and other grade 4 employees with effect from 1/1/2022. The petitioner name is figured as serial number 6 in the said order. All these orders is the manifestation that the petitioner served the department continuously as regular employee till she was released. Service work was also open, Lordship. Seniority list maintained, agreement granted, and the case of the petitioner was verified along with others. All this, Lordship, is a manifestation that the petitioner served as a regular employee in the department for 24 years. However, Lordship, after utilizing her service for 24 years, by the employer, she was released without any pension benefit, Lordship.
What is the number of years of service required to get a pension? Minimum number of years.
Qualifying length of service as per the pension rules,
Yes,
15 years, if I'm not mistaken.
15 years. See, you're saying that OM of 2004 is there. This OM of 2014 provides that regularization will be done as per the available regular vacancies.
Yes, Lordship.
50% of the regular vacancies of similar arising a year will be reserved for work charge employees, remaining 50 by normal rules.
Lordship.
The question is that during your service career, you never asked for regularization. You made a statement here, but there's no document available.
There's no record.
At how
There's
you
no
have
record.
approached. And question is, was there any vacancy at that time?
So, Lordship, my only prayer before Lordship is to issue direction in terms of the law laid down by the apex court as well as by the Honorable Court to regularize her service just for the purpose of pension. I'm not claiming any other service benefits. Just for the purpose of pension, Lordship.
You have reached your superannuation age. You cannot go back into service.
Yes,
You cannot claim.
yes, Lordship.
That's all.
That's a lot.
Okay.
Obliged.
Yes.
May I please, Your Lordship? Lordship, I have clearly stated in my affidavit, paragraph 5 and 6, Lordship. To the petitioner case is covered by the office memorandum 17/3/2015, but he is not eligible for regularization, Lordship. And secondly, his part of his memorandum dated 22/9/2024, the case of the petitioners is not eligible for regularization because there was no vacancy at that point of time, Lord.
Where is that?
Paragraph 6, Lordship. In my affidavit, page 3. So, Lordship, the petitioner case cannot be regularized retrospectively, Lordship, in terms of the office memorandum dated 22/9/2004.
Was there any exercise done?
Lordship,
Why was she not considered for regularization?
there was no available vacancy at that point of time, Lordship.
At that point of time means when?
When the petitioner was in service, Lordship.
She was in service for 24 years. So 24 years there was no vacancy.
Lordship, at that point of time, yes, Lordship.
How can it be?
There was no vacancy. So he cannot be regularized in terms of the
24 years, nobody retired.
22/9/2004, Lordship.
Everybody's in service for 50, 60, 70 years over.
And here, Lordship, the petitioner have approached only after 3 years after her retirement. So, Lordship, here the petitioner suffered delay and laches, Lordship.
No, technically part, you may be correct. I had also pointed out
Lordship.
that why you're coming now? You've retired already. Why are you coming back and taking us back into time? But question is, see, was anybody regularized at all while she was in service? And why was she not taken into consideration? You've just made a sweeping statement that there was no vacancy. Does it mean that there was nobody regularized for the last 24 years?
Lordship, for that, I have no record, Lordship.
So, but you've made a statement here. So, going by this, it is not probable that for 24 years, no, there was no vacancy at all, and nobody was regularized at all. In a way, you have framed the policy of 2004 that there are many work charge employees and no fresh appointment will be made. Whoever is appointed, they will be considered for regularization. 50% of any vacancy shall be reserved for them. So this scheme looks very good, but was it applied or not? That is the issue.
Lordship, for that, if I may be allowed to take instruction. And Lordship, there is no fees memorandum or scheme formulated by the state government.
Scheme.
Scheme or formulated by the state government to
But
give
what is this?
pensionary benefits to the person who are not regularized, Lordship.
No, of course.
There is no scheme.
There's no scheme. Not only there's any scheme, but it cannot be given.
Lordship.
It's as simple as that. Temporary servant cannot be given pension unless you are regularized. So now to overcome that, petitioner says, you regularize me, even at this stage also, so that I can get some pension. Now, between this, you see, the service rendered, where is this scheme?
Page 34, Lordship.
Does it indicate anywhere that in order to be considered for regularization, you have to serve at least so many years like that?
Yes, Lordship, in the office memorandum dated, it's in
2004.
the 17/2015, it's there, Lordship.
2015, nobody is claiming on that, so we did not bother ourselves, 2015. But anyway, for guidance, let us see what does it say, 15.
Page
Point
31.
1, Lordship. In my affidavit, page number 6, Annex 1.
To be regularized, how many years you have to serve first?
30 years. The person should be 30 years, Lordship.
30 years will be
Okay.
regularized. Now, as per the 2004,
Page 6, page 10, Annexure 2, Lordship.
now this 17 March 2015,
Lordship.
does it say that this is in superannuation of the earlier OM?
No,
In supersession?
no.
There is no qualifying years of service to be considered for regularization
No, Lordship.
as per 2004.
No. It should be as per the seniority, Lordship, as per the scheme.
Seniority cum merit.
Lordship.
What was your position in seniority? Verification of work trust scheduled employees. This is seniority or this is just like that? In no
Lordship,
particular.
I don't have a seniority list to show the senior position. However, Lordship, page 39, this,
You're at serial number 6.
that is serial number 1. All those are chairman of the committee, Lordship. Chairman, Lordship.
Then
They are not employees.
they are not employees.
Yes, Lordship.
What are they then?
So it appears that the petitioner is the senior most.
Chainmen are not employees. What do you mean?
Oh, chairman, oh, Lordship.
Chainmen.
Chairman, that is different category, Lordship. I'm Khalasi. It's serial number 6. So among the Khalasis, the petitioner is in top, Lordship.
So you get instructions. How many Khalasi has been regularized?
Lordship.
Who were, you know, like who were, what is your good name, please?
Pichano.
Please write Miss Pichano, learned government advocate,
Lordship.
appearing for the state respondent shall obtain instructions as to how many work charge employees working as Khalasi. Which department is this?
Order, Lordship.
In the Directorate of Irrigation and Flood Control, Government of Nagaland.
Presently, it is Water Resources Department, Lordship. That has been renamed as Water Resources Department.
Bracket erstwhile, comma, now renamed as
Water Resources Department.
Water Resource Department have been regularized since, what is the date of your appointment? 22?
1998, Lordship.
Not date.
My
Not
appointment,
the year.
Lordship.
The date,
22/4/1998.
since 22/4/1998. Up to 15/12/2022. By the next date. When can you get the instruction?
Lordship,
It is from this Kohima typewriter only, Lordship.
after 1 week, Lordship, please dispose after 1 week.
So 1 week,
Lordship.
next Tuesday,
Lordship, Thursday.
this Thursday.
Next Thursday, Lordship.
Why so far away?
Trustee. Lordship, trustee.
Any difficulty?
On Tuesday, Lordship.
Make it
Trustee-
Tuesday.
Yeah, yes, Lordship.
You just have to find out how many, 10, 15, 20 people, just get the documents also. Do you want to know whether, what did I say last?
2016, 15.
Did I mention about the OM? Okay, just read them. Shall it? S2, how many? Before, by the next date, no, you just add this. This, in terms of the office memorandum dated 22/9/2004, issued by the Government of Nagaland in the Personal and Administrative Reforms Department, bracket Administrative Reforms Branch, by the next date, huh? At least again on Tuesday. Give the date. Okay, that will be the last part, okay? Now I'm giving you the beginning part. Right, Mr.
Wati Jamir.
Wati Jamir, learned counsel for the petitioner, who submits that by filing this writ petition, please take your seat, both of you. I'll just dictate a few facts. By filing this writ petition, the petitioner prays for a direction to the respondent authorities concerned to regularize her service as work charge Mali under the establishment of what is that? Establishment of
Water Resources Department.
Water Resources Department. In view of the fact that she had rendered more than 24 years of service as on work chart basis, till she was released on attaining the age of superannuation.
Page 26.
On 30/11/2022, bracket AN, by release order dated 15/12/2022. Next para. The case of the petitioner is that she was appointed as Mali on work chart basis under the establishment of executive engineer, irrigation and flood control, bracket works division, Dimapur, in the pay scale of rupees 800-1475 per month, with some other with other allowances as admissible. Stop. According to the petitioner, she rendered her services diligently and to the satisfaction of all concerned. Stop. Her name. No, stop. Then her name, cancel that. She had also received the admissible increments and other benefits from time to time. Stop. The verification report regarding the work charge and casual employees submitted by the Deputy Commissioner, Dimapur, Nagaland, to the Principal Secretary and Commissioner, Nagaland, on 8/11/2019. Also shows our name. Where's our name?
Serial number 11.
at serial number 11 of the enclosed annexure to the said letter. Stop. Similarly, she has received our annual periodical increment given to all grade 4 casual employees with effect from 1/1/2022, issued by order dated 17/1/2022 by the Executive Engineer, Water Resources Department, Dimapur Division, wherein her name is also shown at serial number 6 of the list prepared. So according to the petitioner, despite having worked for more than 24 years, she was released from service without being given the benefit of regularization so that she may get pension on her retirement. Mr. Wati Jamir, learned counsel for the petitioner, submits that the state government in the Personal and Administrative Reforms Department have come up with an office memorandum dated 22/9/2004, notifying the policy and scheme for regularization of the services of work charge employees. Stop. In terms of the relevant provisions of the office memorandum, the learned counsel submits that 50% of all regular vacancies of similar nature arising in a year is to be reserved for regularization of work charge employees, and the remaining 50% to be filled up as per the normal recruitment rules. Stop. Regularization, however, would be subject to the employee concerned possessing requisite qualification, and the same would be on the basis of seniority cum merit. So he submits that although the petitioner had approached the respondent authorities while she was in service to be considered for regularization, the same was not done. So finally, when her case was considered, after she is superannuated, the respondent authorities have taken the stand that since her case is not covered by office memorandum dated 17/3/2015, which requires a work charge employee to have completed minimum 30 years of service and having and being provided pay scale. Please read the sentence, the last part. No, last. The last part only, just 2-3 lines. Her case was rejected since she did not have the required number of years of service. So the learned counsel submits that the petitioner does not claim the benefit of office memorandum dated 17/3/2015, but that of the office memorandum dated 22/9/2004. He submits that since the state government has framed a policy guidelines for regularizing the master role work charge employees, the same should have been applied in case of the petitioner before she attained the age of superannuation. He also submits that the apex court in the catena of decisions has held that it is the bounden duty of the state as a model employer to consider regularization of its employees employed on work charge basis. In this connection, the learned counsel has relied upon the decision of the apex court in Prem Singh versus State of Uttar Pradesh and others, 2019, 10 SEC 516. And the decision rendered by a division bench of this court in State of Manipur and others versus Kishore Iqbal Singh and others, 1997. This is 11 or 2? Volume? It's written in Roman. I think volume 2 only. It cannot be 11 volumes. 1997, 2 GLT 202. The learned counsel further relies upon the judgment and order rendered by a division bench of this court in writ appeal number 35 of 2022, bracket State of Nagaland and others versus Sri Angpei Konyak, close bracket, by which the direction of the learned single judge to regularize the services of the writ petitioner who work as a work charge employee by judgment and order dated 11/4/2022 in WPC number 21 of 2021 was upheld. Of the learned counsel therefore submits that the case of the petitioner should be directed to be considered by the respondent authorities for regularization so that she can have the benefit of pension. Next para, per contra, Miss Channel, learned government advocate, submits that it is too late in a day for the petitioner to seek for regularization of service in view of the fact that he has already retired on superannuation with effect from 30/11/2022 bracket AN. He submits that the petitioner has not rendered minimum 30 years of service in order to be considered for regularization of service in terms of the office memorandum dated 17/3/2015. Therefore, she's not entitled to be considered for regularization. She further submits that at any rate, there was no vacancy in the department at the relevant time so as to consider her regularization in terms of the office memorandum dated 22/9/2020, 22/9/2004.
Lordship, if I may be allowed to make one submission. Lordship, the apex court judgment cited by the counsel for the petitioner also talks about an employee who has discharged the duties with the department for 3 to 4 decades. That means it must be for 30 years. However, the petitioner has only served for 24 years, Lordship. So 30 years is the yardstick to apply for regularization, Lordship.
She further submits that the authorities relied upon by the learned counsel for the petitioner would not be applicable in case of the petitioner, in view of the fact that in those cases, the minimum service years of service rendered by the employee concerned was 30 years and above, whereas the petitioner in the present case has rendered only 24 years, and she has since been superannuated on attaining the age of 60 years. She therefore submits that there is no merit in the writ petition and the same should be dismissed. Then the beginning part I dictated, what was that? That you put on the last part. So you get the instructions. We'll see.
For orders, item number 22.
Yes.
This is newly implemented respondent number 7. Whether duties has been affected or not.
Lordship, we've tried serving through Dusty mode, but we could not meet the respondent number 7 yet. So currently in 2 weeks' time, Lordship.
Respondent number 7.
Yes, Lordship.
The private individual.
Private respondent.
Okay. What is the matter regarding service?
No, this is regarding the allotment of land, Dimapur.
Allotment of land.
Lordship.
In favor of the respondent number 7.
Yes.
How much time required?
2 weeks' time, Lordship.
Okay, as right for further 2 weeks' time is granted to the petitioner to effect service of notice upon respondent number 7 by way of Dusty to the registry of this court. Once the once the notice is effected, the petitioner shall file an affidavit as proof of service. List again after the summer vacation.
For orders, item number 23.
May I please, Your Lordship?
Yes.
I'm appearing on behalf of my senior, Sir Tumbok Corner. Lordship, we have served copy to the newly implemented respondent number 6, that is the finance commissioner, and we have also filed the amended cost title. last month.
Hmm.
So this matter be listed after summer vacation.
Affidavit filed?
Yes,
Not yet, Lordship. Lordship, we have to issue notice, Lordship, to the newly inflated Finance Commissioner.
Okay, Finance Commissioner is impleted.
Yes, Lordship.
Has a respondent number?
6.
Where is your amended cost title? Oh, it is here. Additional Chief Engineer, is it? Additional Chief Secretary, Finance and Additional Chief Secretary and Finance Commissioner. This is correct?
Lordship, I think it's Finance Commissioner, Lordship.
They have written Additional Chief Secretary and Finance Commissioner, Government of Nagaland, Department of Finance.
Lordship, it's only Finance Commissioner. That's what I think. It seems there's an error here, Lordship, so
This was allowed by which order? Implement. There's an IA.
speak petition, Lordship.
This is what they have paid also. That time nobody objected. You should have objected regarding the nomenclature. An application for implement of Additional Chief Secretary and Finance Commissioner, Government of Nagaland, Department of Finance as respondent number 6.
Lordship, since I'm appearing on behalf of Devika, Lordship, she has instructed me that Finance Commissioner will be impleted. That was the instruction given to me, Lordship, so my apology, Lordship.
Ms. Pichano appeared that time. The time of allowing the IA, no? Who's Pichano?
She left.
Oh, she was here, no?
Yeah, she was here.
Oh.
But this matter is taken up by
By Devika.
Yes, Lordship.
So will this cause any problem? Nomenclature.
I'm not sure, Lordship. Oh.
Please be sure. I'll allow his prayer orally. It is a Finance Commissioner. Are you sure?
I'm not
It is
sure.
not.
I'm not sure, Lordship.
Then,
If I may, Lordship,
yes.
we have implemented the respondent number 6, the finance, the commissioner.
Correct. So what is the correct nomenclature?
Additional Chief Secretary and Finance Commissioner, Lordship.
It is correct.
Correct, is correct. We have filed the amended post title. And we have served the copy to the. We have served the copy this morning only, Lordship, to the newly implemented respondent number 6.
How?
Through the council, Lordship.
Okay. You have received copy?
Yes, Lordship, this morning.
So do we have to issue notice required?
Yes, Lordship. We have to issue notice, Lordship.
Okay. He's right. By the white order dated 4/5/2026. Additional Chief Secretary. And Finance Commissioner, Government of Nagaland, Department of Finance was implemented as respondent number 6. And the petitioner was asked to file the amended cost title. Stop, the same has been done. Stop issue notice to the newly implemented respondent number 6. returnable by 3 weeks. Miss
S. Young, Lordship.
S. Chang, learned government advocate,
Yes, Lordship.
accepts notice on behalf of respondent number 6. And therefore, no formal notice is required. List again after 3 weeks. Respondent number 6 to file the counter affidavit. In the meantime, anything else?
Lordship, Lordship.
Please, Lordship.
Hmm.
Lordship, I beg to mention hearing item 31, Lordship.
Morning also you mentioned, isn't it?
Yes, Lordship.
Please write Mr. Pakin Richabo, learned counsel for the petitioner, is said to have some personal difficulties to appear before the court today. On a mention made on his behalf by Mr.
Certificate of.
Uh, where is that?
Lordship, I'm appearing for respondents 2, 3, 6, and 7. If my presence may kindly be reflected. Otherwise, I have no objections to the prayer for adjournment.
Hmm. Okay, on a mention made on his behalf by Mr. So and so. Item 12, his name is there. Item 12. Matter stands adjourned. To be listed again after the when?
Application.
Some occasion. Mr. Imti himself, learned additional AG, appears for the state respondents, while Mr. Sentianger, learned counsel appears for
2, 3, 6, and 7.
respondent numbers 2,
3, 6, and 7.
3, 6, and 7. All right.
Deeply obliged, madam. So.
Oh. This is exhausted. No, it's still there, isn't it? Okay, we'll come back at 2. Yes.
What in terms of the order dated 15/5/2026, we have taken steps upon the respondents number 6, 7, and 8.
So there's no return service report.
Yes, Lordship.
We post it again after 2 weeks.
Lordship.
All right. Await service report. No, cancel that. List again after 2 weeks to await service report from respondent number 6, 7, and 8.
Much obliged.
For orders, item number 25.
25. Same thing. List again after 2 weeks to await service report from respondent number 4.
Lordship, so my apologies.
Just-
I'm in item number 25.
So after 2 weeks,
2 weeks.
there's no AD record from the return from respondent number 4. So let's see.
Lordship, my presence will be important because
Okay, Mr. Hosiko Forte, learned counsel appears for the petitioner.
Lordship, I'll oblige, my lord. Thank you.
For orders, item number 26.
Lordship, as directed by this honorable court, service of notice upon respondent number 2 and 5 have been taken by way of speed post. However, service is still awaited, Lordship.
Same thing. List again after 2 weeks to await service report from respondent numbers 2 and 5. Your good name, please.
Loreno,
Sorry,
Loreno,
Miss Loreno, learned counsel appears for the petitioner. Petitioners.
much obliged.
For orders, item number 27.
I'm appealing on behalf of respondent number 3. Is it CGC? I'm appealing
1, 2, and 3.
1, 2, and 3. Your Lordship.
Okay.
I need 4 weeks time, your Lordship, to file my reply. This is my first appearance, Your Lordship.
Reply or your counter affidavit.
Yes, Your Lordship.
Your good name, please.
YP Gupta.
Mr. YP Gupta, learned counsel. Submits that you are standing counsel or
Yes, you are CGC, Your Lordship.
YP Gupta, learned CGC, submits that he will be appearing for respondent numbers 1, 2, and 3. And he prays for how much time?
4 weeks time.
4 weeks time to
But
file.
after petition,
4 weeks time to file counter affidavit. Okay, what about number 4? Respondent number 4?
Service is still awaited.
Then you write one more line. As such, formal notice to respondent numbers 1, 2, and 3 is waived. List again after the ensuing summer vacation. Service report upon the respondent number 4 be awaited. Respondents are at liberty to file their counter affidavit in the meantime. Your good name, Miss
COVID Lordship. Kovi.
Kovi.
Yes.
Miss Kovi. Sukru.
Yes.
Learned counsel appears for the petitioner.
Your Lordship, my name will be reflected in the cause list finders.
Name of Mr. So-and-so, learned CGC, will be reflected.
Interim may be extended, Lordship.
Interim order passed earlier shall continue to the next date of listing.
Much obliged.
Much obliged, Your Lordship.
For orders, item number 28.
Lordship, I'm the applicant in this IA 146 of 2025.
Yes, there are two IAs.
Yes, there are two IAs. One is filed by my
learned friend here. And that is for embellishment of the village council. Lordship, my IA is a deletion of my name, the village council, as a party respondent in this case.
IA 146?
Yes, 146.
146. You don't want to be a party.
Lordship, in fact, the issues involved in this case does not warrant my presence.
Okay.
Because my
You're pleaded as respondent number?
initially, Lordship, I was pleaded along with the photo mandem. I do. In the writ petition, Lordship. In the writ petition.
Yes. You are respondent number in the writ?
One.
Respondent number 1.
What? It is two institutions has been clubbed together at page 14 of the writ petition.
Yes.
The Real Sangha put to maintain, that is the traditional and customary institution of.
You're respondent number 1 only.
And village council / village council.
Okay.
So, Lordship, my prayer is IA is that my name should be deleted from the area of.
Okay. Respondent number 1, isn't it?
Yes.
Yes, what do you say?
Lordship, it's not like that, my lord. The respondent number 1 has been added as Putumandan / the village council. And their objection is that Putumandan should be there, village council should not be there. That is the stand. That is the objection.
Lordship, may I just complete?
So I finish them, Lordship, I can show why I have added them as such. According to me, the Putumandan is also the village council.
Lordship, the impugned communications and informations, all these impugned informations were passed by two institutions, Lordship, two customary institutions. Two of them has been passed by the Putumandan, and two has been passed by the Yang Yamsen Sensu Mongtang, that is the Citizens Assembly. And the village council, as a statutory body, had nothing to do with that. That is my prayer. So, since the grievance of the petitioner, in this case, is directed against the 4 impugned informations and communications.
So if we delete village council, then it is okay?
That's my prayer, Lordship.
If village council is deleted, then it's okay?
Yes.
Putumandan may remain.
Putumandan will remain.
Youngest women, what is it?
This is the
Young
custom.
Sangha.
Yeah, real Sangha.
Young Sangha will remain.
Putumandan.
Putumandan will remain.
Yes.
But village council should be deleted.
That's what,
This is
that's
what-
my prayer.
Okay.
Because I had nothing to do with the impugned actions as alleged by.
So,
I am praying for Putumandan.
okay.
The respondent number 1, there are two institutions clubbed together. I represent Putumandan. He is praying for deletion of the.
Lordship,
No, you represent who? Village council?
village council. Because village council is a statutory body created under the Nagaland Village Council Act of 1978. Lordship, the history is that in our areas, the Putumandan was the institution all along prior to 1978. But with the coming of the 1978 Act, the village council has been created. The functions are different, Lordship. The two institutions.
Okay.
Putumandan deals with the customary practices in
What is a Putumandan? It's a body of persons.
body of persons.
They're elected or what?
They are nominated
Nominated by
the tribes
the tribes.
in the clans,
Nominated.
sub-clans. Not tribes, Lordship, clans.
Clans by the
Clans.
tribes.
Yes.
Okay.
Yeah, all are, they represent different clans.
Different clans, okay. Now, they're still in existence?
They are, Lordship.
And what is the role of what is their role now?
Lordship, mostly deal with the customary practices and traditions of the village.
Okay.
And the village council, the statutory body of the village council is still by the Village Council Act, and the powers and functions are defined under Section 12 of the
So
Act.
what is the difference between them? Village council also has the function?
Village council is an
Customary-
auxiliary body of the state machinery.
Correct. So on customary matters also, they have a role?
Lordship, if I may say so, no.
They don't
The
have-
customaries are mostly dealt by the automaton. Because
So what do they do, village council then? What is their role?
what the your rules and functions are defined under the act.
Like, for example?
Lordship, they are most, may I take your lordship to the village council act? Section 12.
There's a term,
There is 5 years term, your lordship,
5 years
for the
term.
village council.
They're elected.
They are also nominated and they are approved by the state government.
They're nominated, not elected, nominated. Nominated by the people.
Yes, the clans will, representative of the clans, similar to the Potumandan.
We have got government agencies in carrying out development.
Yes,
work.
these are all-
Then to borrow money from government banks,
Yes.
I should say, for applications also. Then aid, lend money, this, that, then. To realize registration fee. To formulate development schemes. So that customary part is not there.
No, not a single customary part is mentioned in.
So their role is
Alright.
distinct. Potumandan is on
Yes,
customary.
the powers and function of the institutions are different.
Now, impune order is passed by whom?
The impune orders are passed by the Potumandan, 2 of them.
Okay.
And the 2 are passed by the, were passed by the, there is another. Yes, respondent number 2, that is another customary institution of it.
Can we just have a look at the impune orders?
Lordship, page 119. 119 is one of them. Annexure 29. Then
This is in vernacular.
the translation is there, my lord. Translate copy is the next page.
Next page.
Then 101 is the other one, my lord. Page one.
Where is the translation?
Translation is
Next page.
123.
123.
Starts from page 80, in fact.
It's regarding excommunication.
Yes.
Excommunication.
Then signed by whom? Copy to so and so. But who are the signatories?
Yes, my lord.
Which one, your lordship?
Signatories to this order information. This is information, not an order also.
Yes.
It's a general information.
No, my lord, they have taken the decision and the information has been circulated through this.
Oh, I see. Who has taken this decision?
This is the Sensu Montang lordship, R2. 119.
Yes, what is Sensomandam?
This is an association of the citizens
Okay.
of the village.
Then where's Putumandan then?
Lordship, this is one passed by R2.
I see. And the other one?
And lordship, let us begin with the, from page 80.
80.
Yes, that's one information. This is issued by the Butumandan. 80, the translated,
81 is translation.
81 is the translated copy. This is 4/4/2024. This is passed by the,
You are summoned on so and so to the Vyong Sangar Tatar village head Salan court to discuss the matter.
yes, this is the Butumandan law,
It's not VC, not village council.
not village council law.
Okay. So that's why you are objecting that. You say
Yes.
that village council, we have not done anything.
We have done nothing, lordship.
Okay.
And the next one is
133.
Prerogative lordship, 101. This is publication in the newspaper by R2, Lordship.
What is this?
This is the paper publication, Lordship. The translated copies.
Excommunication.
Yes.
This is by R2.
R2, Your Lordship.
R2. 102 is by R2. 123 is also by R2.
No.
Oh,
103 is 103N, that is 104, the translated copy, is by the Putumandan.
Okay.
So, Lordship, the grievance of the petitioners are against these four imbued information and.
Okay, 104 talks about village council.
Yes. No, Lordship, this is Young Yimsen Ryong Sangar Tatar.
Village council is there. Translation. 104, you see?
No, council.
Yeah, this is Lordship, dear petition, Lordship. So this has been wrongly interpreted as.
Okay, this is a translation of which one?
This is translation of the
103.
103, Lordship.
Okay, village council is not mentioned in 103.
Yes.
Okay.
In the body of the original text, Lordship, the village council is not reflected.
Young Sangar Tatar. What is Tatar?
Lordship, roughly translated, it will be the Potomintan.
Sorry?
Potomintan. That is the. Yes, the elders.
Elders. Elders.
Who takes the decision.
Okay.
They represent the tribes, clans and sub-clans.
Okay.
So, Lordship, all these four impugned communications and informations were passed by two customary institutions. And the village council as a statutory body have nothing to do with it.
81 is by R2.
Yes, Lordship.
102 is by.
No. 81 is by R1. That is the traditional institution.
I'm sorry, yes. 81 is by R1.
Yes.
Then 102 is by.
102 is by the R2, Lordship.
Then one more.
103 is by the Ryong Sangar Putu, that is the Putumintan.
$104 is by
10 by
R1.
R1, the Putumintan.
Okay. Then one more is there.
Yes.
133.
Yes. 119 is by the by R2.
R2.
Yes.
119 is dated 10/12/24.
Yes, Lord.
This is by R2.
Yes, Lord.
Okay. R1, R2, R1, R2. Okay. Translation, you say village council is not there.
Yes.
They have added this somewhere wrongly.
In the original text, the village council is not reflected.
So that is your limited there.
Yes.
Okay.
In 146.
So if it is allowed, you need not participate. Correct.
Correct, Lordship. Lordship, may I just take your Lordship to one. The Village Council Act, Lordship, Section 22. Under this act, the Village Council, I am under the control of the state government. The state government.
I was about to refer to this. From this act itself, I will show that village council and Putumindan are the same one and the same entity. Lordship, may kindly come to section 4. A village council shall consist of members chosen by the villages. According with prevailing customary practices and usages, my lord, we kindly note that, customary practices and usages. The same be approved by the state government, provided that hereditary chief GPs, aunts shall be ex-official members of the council and shall have a voting right. So, Lordship, Section 4 deals with constitution of the village council. It says it will be chosen in terms of customary practices. In terms of customary practices. Now, my lord, this is our village in the district of Mokokchung. The village has a Putumandan. The members of the Putumandan are the village council members. By virtue of being the Putumandan members, they become the village council members. Their names are sent to the government, and government approves the list of the Putumandan members, and they function as village council. Now, Lordship, may kindly come to section 6. Lordship, 5 and 6 deals with qualification for members of the village council. 5 and 6. The heading is qualification of members, my lord. Now, Lordship, just read Sect 6, which is renewal. Every village council shall, unless otherwise dissolved by the state government, shall continue for 5 years from the date of appointment, provided that the said period be extended by the state government by a notification in the Gazette for a period not exceeding 1 year at a time. All B, my lord, members shall hold office during the life of the village council, provided that the member chosen to fill a casual vacancy shall hold office for the remainder of the term of office of the member whom he replaced. My lord, B proviso 2, second proviso is important. Provided further that village institution, which were traditionally established like the Putumandan, my lord, in our area, recognized as a village council, shall continue to function as village council according to respective custom and usages, my lord. So the Putumandan, my lord, Washington, the Putumandan, once it's recognized by the government, will function as the village council. And Lordship, custom, they can function in accordance with custom and usages. The village council, they
So there are two identities.
There are
two identities, same people, same members, but two identity. One is as a village council for developmental works, loan, this, that, and the other one is as a customer.
Yes.
Customary body.
Lordship, now.
So here we are concerned with the customary body because of it talks about excommunication.
Excommunication. Now, my lord, even the village council can exercise custom and customary powers. It's very clear. Here, my lord, the village councils, according to respective custom and usages, it will function according to custom. Lordship, may kindly provide that further. The village institutions, so village institutions which were traditionally established like the Putumandan, is already there, my lord, in our area and recognized as village council, and this has been recognized as village council, shall continue to function as village council. So they are also functioning as the village council, my lord, according to respective custom and usages. Now, my lord, this Putumandan was chosen
according to the respective custom and usages. They are recognized as village council.
Yes.
So that's why they also will be considered as village council members.
Yes. So, my lord, correct.
But the question as to whether they'll function as per the traditional or the thing
will be
different.
As a Putumandan, they have the customary powers. And as per the, since they have been recognized as the village council, my lord, they have the additional powers under the Act. They are functioning as customary body, exercising customary powers. And once this recognition comes, my lord, they are also having the additional powers given to them under the Act. So now, my lord, lordship, there is one aspect. Now, lordship, this is no longer a res integra, my lord. This has been settled. The village council of Putumandan is a village council, has been settled in previous by this honorable court in early judgments.
Okay.
Lordship, may I just refer to two of them, 2 or 3. My lord, the first one is, apart from this, my lord, I have added them as parties in such a manner, my lord, that Putu / the village council, Putu, because this is one ground, and the other ground is the conduct, my lord. I will show.
Conduct means?
Conduct means they have acted as the village council. They have acted as the village council. And therefore, they have held themselves out as the village council. I will be referring to the documents, the issue leading to this excommunication, my lord. While this started sometime in 2023. And while dealing with this issue, the Putumandan has held themselves out, or through the communications documents, which is a part of the petition, my lord. From themselves, they also call themselves as the village council. They themselves call themselves as the village council. And that is the predicament, my lord. They have said village council somewhere. They've said Putumandan somewhere. In the same letter, they've said Putumandan village council. Now, whom do I make a party, my lord? If I say make a village council, not make a Putumandan, they'll say the village council is taking this, not the Putumandan. And vice versa, my lord. That is precisely the reason why I have put this short between them. So both this, I'm in a very difficult spot. If I make them one a party and not the other, my petition will be objected on that ground. Say that you have not met that party. The purpose of saying that Putu Village Council is not a party to this issue. There is a reason behind it, my lord. The reason is they have already said that this is a customary body and this is a statutory body. And once it's a statutory, not a statutory body, they will resist on the ground that it doesn't come within the meaning of state and all that kind of issue. Of course, that cannot be, that will hold water, my lord, because of the BCCI case, where pervasive control over the society, regulatory, monopolistic control, it's a private body, will come in the ambit of Article 226 that Supreme Court has already decided. Now, Lordship, may I kindly come to that case law I was referring to, and then my only must appeal also, please. It's here, I think. Lordship, may I kindly see 2019 GLT. Well, appeal ingin naik kita yang 2019 1 GLT 409. Lordship, Justice Katasar Singh has retailed a very painstakingly written this judgment. This also deals with excommunication, my lord. May I just go to for the purpose of this interlocutory applications today, my lord. May I just go to the paragraph. There is paragraph 25 and 26. May I just read paragraph 25 and 26? Page 420, my lord.
Yes.
Since the village council has been empowered to administer justice in village accordance with customary laws, I will respond. Here, a similar plea was taken, my lord, that Putumandan and village council are different. In village, in accordance with the customary laws, either respondent number 4 and 5, the local commission represents the village council exercising the executive authority these bodies, as they cannot be two entities exercising authority to administer justice on the basis of customary laws. If the respondent number 4 and 5 represents the village council as contemplated under the Act, they are amenable to jurisdiction. If they are not village council as claimed by them, but since they claim to have the monopolistic right as regards the implementation of customary laws in the village, for the reasons discussed above, they are amenable to jurisdiction. Otherwise, there are many bodies who cannot issue such directives. 26 months. Respondent number 4 and 5 have disclaimed that they represent the village council. However, it has been stated in para number 2.2 of the affidavit in opposition that the respondent number 4 and all village customary institution within the Chujung village of Mokchung, district of Nagaland state, specifically Salat, Putata, Salang, or Putumandan in general. The composition and hierarchy of Putumandan has been explained in subsequent paragraph number 2.3. This self-acknowledgement by respondent number 4 that it is known as the Putumandan half settles the issue in favor of the petitioner. That the respondent number 4 is a statutory body and able to reach jurisdiction for this clearly provided under second proviso to Rule 6 of the Nagaland Village and Area Council Act 1978, the village institution which were traditionally established like the Putumandan area and recognized as the village council shall continue to function as village council according to respective custom and usage. My lord, section 6 is quoted. Now just go to the other part. Thus, Rule 6 of the Village Council Act recognizes Putumandan in our area and also village council as the aforesaid Act. In view of the provision, respondent number 4 and 5 cannot deny coverage under Article 226 of the Constitution. So this was the finding of the learned single judge, saying that village council and Putumandan is the same. Lordship, then what happened? They filed an appeal. Excommunication was quashed, my lord. An appeal was filed against this. In the meantime, the parties came to some understanding, my lord. The parties came to some understanding, and my lord, according to the settlement, the appeal was closed. However, this was passed, my lord. May kindly come to the last page. And based on this, the respondents will argue, or the applicant will argue that the case has not been settled. My lord, may kindly come to this. Recording the submission made in page 4, my lord. Recording the submission made by the senior counsel for the appellant as well as the settlement such and such, between the appellant and respondent number 1, which is reproduced here and below. This appeal accordingly stands closed. However, the issue as to whether New Summer Putu Tata Salang is choosing among village council or not, and whether New Summer Putu Tata Salang exercise public function is kept open. My lord, the judgment of the learned single judge was not interfered, has not been set aside. He just said that issue. This has no meaning, absolutely. It has not set aside the judgment passed by the Justice Kotasar Singh. In fact, the judgment has been followed recently, my lord. Lordship, in this case, this is Chalukamba. This was decided on, my lord, in 2024. May I just go to the new portion, my lord. From paragraph 14 onwards, page 10. The respondent number 4, again here also, my lord, Chundia Batum Sanga Putuman, another village, but Putuman is involved, my lord, is a village institution which comes within the ambit of the second proviso of section 6 to the Act. One of the issues which has come up for consideration in that case, the case I just referred, my lord, was whether a village institution which comes within the second proviso of section 6 of the Act is amenable to reach jurisdiction under 2 to 6 of the Constitution of India only. The respondent number 4, therein, was a similar village institution like the respondent hearing, known as the Putu Mundan. The respondent number 4, therein, was a Chujulang Village Council or New Summer Putu Tata Salang, and it was concluded that the institution was an Naga village customary institution belonging to Chujulang village of Mokshun district of Nagaland and was known as Putu Mundan in general. It is concluded that the village institution could not be treated as a village council just because its members also members of the village council. Same stand was taken there, my lord. Following the decision, the cricket control of cricket in India versus such and such, reporting such and such, the court has observed that even the respondent village institution in the form of Putu was not a court or a statutory authority as claimed by it, because of the pervasive and monopolistic control of the villages with regulatory powers in areas under its traditional jurisdiction and discharge of public function and duties, such kind of bodies amenable to reach jurisdiction. Lordship, may I just...
Yes, read.
Lordship.
Please read.
Okay. It has been held here in that village institution, which were traditionally established like the Putu and recognized as village council, shall continue to function as village council according to respective custom usage of Rule 6 of the Act, recognized Putu also as village council under the Act. So this also, so Mala is directly on the point. Such body cannot be coverage under Article 226 of the Constitution. 16, Mala. The fact that the Putu has banished and excommunicated the petitioner from his own village. So, Lordship, that so Putu is also the village council. That was also held in this case, my lord, relying on Mayan Lima's case. Yeah. So, therefore, my lord, it's no longer res integra, my lord. This matter has been settled. The issue has been settled in previous cases, my lord. Similarly, my lord, we can see.
So, what was the decision in this case?
It was Putu is a village council, and the decision taken by the Putu or the village council was interfered with, my lord, set aside. Excommunication. Paragraph 17, my lord. The last line, Mala, paragraph 17. As a corollary, the petition can remove the village and he can be subjected to social boycott expulsion from Julia village as directed by respondent number 4, Julia village council. That is the Julia Madam Sana Putum Bandan. So Lordship, these two cases directly says, and this, the judgment of Mayama has not been overruled or set aside, my lord. It's a good law. And it's
Mayama says that the excommunication order cannot be issued.
No, Lordship, even if it is a private body, let's say it's not a statutory body or a customary body, let's call it, my lord, even then, it is amenable to re-jurisdiction because of where BCCI case has been clearly said that the BCCI not a non-governmental organization, yet it has pervasive control over the one section of the society. So this is amenable to re-jurisdiction. I don't think the Putin will be disputing that right now, my lord. But the issue is, my lord, why did I make the village Putin / the village council? Respondent number one, why did I make Putin public village council? Why I had to make that? And Lordship, can you see? Lordship, can you take my objection? The objection that I filed?
Now, what has happened to the amended petition?
It's still pending, my lord. When I filed this writ petition.
No. The pleadings are completed.
Pleadings are completed, my lord. Pleadings are completed. Well, after filing this.
So why are we concentrating on the parties?
Yes.
So we did or not?
Yes.
Why not go to the entire?
Yes, my lord. That's what I was saying.
Decision.
But
wherein the IA also will be taken care of.
Lordship, it so happened that when after filing, the village council, they filed this IA 146 saying that village council has nothing to do with this. So therefore, they should not be mentioned in the cost title at all as a party. Then it came up before Justice Naya once. Justice Naya was also said that you filed a sanction was made, though it's not reflected in the order, that I should file an application to delete Putumundan and to make Putumundan and village council two separate respondents instead of joining them as one respondent. So therefore, I filed that other application, which is IA number 90.
Okay, 90.
Yeah, 90 is to separate them as two separate respondents.
Arrange them as what?
Make Putumundan one and the village council as 7, my lord.
As 7.
As 7, respondent number 7. Putumundan will remain as 1.
As it is.
As it is.
Village council will remain as 7.
Lordship, why I'm saying this, Lordship may kindly appreciate this. The village council, there are 4 letters that I will show, which will clearly show that the village council also is partly to the decision that has been taken against me.
They are the same person.
They are the same person, my lord. Lordship, may I just show 4 letters, which is part of the pleadings here, which I have enclosed separately in my objection. That will make it very clear, my lord. My objection, my lord, to 146. They said village council members are not involved with this. Village council is not involved in this manner, my lord. But you can see the letters written by them. But it's Putumundan, my lord. Lordship was putting a query. Who had a signatory to these letters, my lord? Lordship has found my objection, my lord. Objection by to the IA of 146, my lord. Ekbar bisari di bito, please.
Okay, page.
Lordship, can you come to page 12 first?
Yeah.
This is one of the letters written by during these issues, my lord. So let's not go to the content, my lord, just to show briefly. Lordship has found page 12, my lord. Lordship, look at the see the writing letterpad, my lord. You see Tata, that is the Putumundan, my lord. Who is the signatory, my lord? Chair, village council, secretary. Functioning as one and same entity, my lord. Village council secretary has written this letter. And then Lordship may kindly come to the next page again, page 14. This is why I have to make the village council, adding the respondent number in the manner I have made, my lord. 14, again, the writing pad, my lord. Again, the village council secretary.
That it's not very legible.
It's not legible, but it is the village council secretary, my lord. Then Lordship may kindly come to page. This is 16, my lord. Again, my lord, the letter had, my lord. Can we see, my lord, chairman and the secretaries, both signatories of the village council? No, Lordship, may kindly see. Another one, this is the most important one, my Lord. Huh? Lordship, may kindly come to page 19. This is a letter written by the Putumandan, my Lord. Putumandan. Here, Lordship, may kindly see this is a notice summoning 3 persons to the Putumandan, by the Putumandan, to come on fort. Now, my Lordship, may I pause here for a moment, Lordship? This is the summon. This is the summon. Lordship, may just keep the date in mind. 2/4/2024, summon on 4th April 2024, page 20. So 3 persons were summoned by the Putumandan to appear before it on 4th April 2024. Putumandan has summoned it, my Lord. Now, allegation is that during this, these 3 persons brought some other people and has also assaulted some of the Putumandan members. And in that connection, an FIR was lodged. Regarding a meeting held by Putumandan. Can you come to the FIR? This FIR will make everything clear. It's an FIR written by the village council, Lordship, you can see that letter had the fees of the village council. What is in bracket, my Lord? Sangat Tatar. That is the Putumandan, my Lord. They themselves have called themselves the Putumandan and the village council as the same entity. And if you look at the content, also they said, we understand on behalf of the village council like to invite the above subject to your perusal and study and necessary action, please. We would like to apprise you that 3 persons, mainly so and so, has from your village, and all 3 are receiving of Chumukidima created rumors in social media against the village council, my Lord, against the village council, stating internally about the village council consequences for interference to Chumukidima. For creating such misleading and unfounded story, the Yumson village council summoned the 3 persons. Lordship, I can see. Yumson village council has summoned. That's what they're saying. But Lordship, the summon shows in the letterhead of the Putumandan, page 19. Page 19. Someone they're acting as the same body. Not just to bring the case and defend the case to create problems, legal problems. My Lord, they're saying these are different entities. And it's clear, saying that village council, the section 6 will also put the village council. And so now, by their conduct, my Lord, can a party, having taken a stand before a certain authority, can they take a different stand altogether? No, Lordship, the law is very clear. No. Lordship, can you see that? No, this, my note, not the main case. Lordship, can you see 2010 3GLT 150? My Lord, can you come to paragraph 11? Yes, my Lord, paragraph 11. Paragraph 11, my Lord, the apex court in such and such held that a party cannot take a stand which becomes contrary to its own conduct. They have already said letters have been written in the name of the village council, in the head, village council and Tatar, same letterhead, my Lord. And now they're saying we are not the same entity. Then, my Lord, again, 2018, my Lord. 2018, 10 SCC, Malena. Suzuki case. Suzuki. Now, get this. Lordship, may kindly go to the last page of this case, my Lord. This is reported in 2018 10 SCC 707. Supreme Court, my Lord. Paragraph number 12 and 13, may I just read it out? Yes. A litigant can take different stands at different times, but cannot take contrary stance in the same case. A party cannot be permitted to appropriate and incorporate on the same facts and take inconsistent shifting stance. The untenability of the inconsistent stand in the same case was considered in such and such. This court want to make it clear that an action at law is not a game of chess. An litigant who comes to court and invokes a jurisdiction must come with clean hands. He cannot prevaricate and take inconsistent position. 13, my lord, a similar view was taken in such and such, ma'am. 12, the doctrine of election is based on the rule of estoppel. The principle that women cannot cooperate and incorporate hers in it. The doctrine of estoppel by election is one of the species of estoppel in bias or equitable estoppel, which is a rule in equity. Taking inconsistent pleas by a party makes its conduct far from satisfactory. Further, the party should not blow hot and cold by taking inconsistent stands and prolong proceeding unnecessarily. This is precisely the case, my lord. And then in Premlata also, my lord, Premlata case by the Supreme Court has held in 2022 6 SCC 585, my lord, paragraph Premlata, paragraph 6, my lord. Paragraph 6, my lord. The respondents or defendants cannot be permitted to take two contradictory stands before the different authorities court. Here in the police, the Reverend Counsel Putu Singh, they have written letters to the parties to us by the college council chairman, secretary. In the court, they're saying it's two different entities. They're not permitted in lordship. Earlier section 115, the evidence act now is 121, estoppel, my lord. A party cannot take a stand which has contrary to the past conduct. So therefore, my lord, this is precisely the reason why this has to be, respondent number 1 has to be elected in such manner, because somewhere they're saying village council, somewhere they're saying Putumandan. But lordship, these are the same person, same people who's in this affidavit. I have also given in my objection, my lord, I have given the names of the village councils which were proof at page 22, my lord. Page of my objection. The objection, my lord. Yes. Lordship, may kindly come to the renewal page 24. This is the list which was approved for the year 2021 to 2026. The list of members of the village council. Page 24 is the Young Muslim village, my lord. There are about 50 people, 50 persons who were appointed, who were recognized as this were the Putumandan members, my lord. Putumandan members of that village, whose names were forwarded as village council members, they were approved. From this, my lord, some has died, some have died, and some have resigned. But this is the same persons who were. So what happens is, my lord, the Putumandan, yes, is for a period of 30 years. The personnel changes, my lord. The personnel or the numbers may change. And each Putu will have a name. This is Rirung Sangha, the present Putu, my lord. The numbers changes, some die, some are replaced, my lord. But the Putumandan is for a period of 30 years. From this Putumandan, my lord, this Putumandan, the members of this Putumandan are also are approved as the village council, and they will function as village council for a term of 5 years. When the term of 5 years expires, my lord, the same person again gets reappointed or reapproved by the government for another term of 5 years. They'll continue till the term of 30 years.
Term is otherwise for 5 years. That's why every 5 years they are again reappointed.
Reappointed, reapproved by the government. The names are sent, and this person, same person, continue as the village council members. And since 6 second proviso clearly says Putumandan shall also function as the village council in accordance with custom and usages. And that's why this honorable court said that in Mayang Lima case that Putumandan and village council are same, and the village council cannot take the plea that they are not Putumandan. And based on that, my lord, subsequent judgment has also been passed. And lordship, though the issue has not been dealt with this in this case, my lord, but here also there's another case where the party respondent number 4 was Putumandan / the village council, which has been entertained by this honorable court, my lord, in another case, though this issue was not discussed therein. So therefore, my lord, Whatever may be the case, the village council is a necessary party. As your lordship has seen, the village council is involved in the case by their own letters. It clearly shows by their own conduct. Tomorrow they will say Malad village council should have been a party. Otherwise, the case is defeated on that ground. Malad, the issue involves Article 2. Malad, I'm barred. No one should marry into my family. In times of death, no one should come to me. I cannot go to the village. My names from all the village name from all the official documents will be removed. I cannot identify as belonging to this village. Malad, these are right by birth, Malad. It's a right of every citizen. Article 21, Malad. And custom cannot override statute. That's settled, my lord. How can custom override fundamental rights? Therefore, my lord, since suggestion was made by by Justice Nair, saying that why don't you file an application and make these two into two separate respondents instead of keeping them as one, clubbing them as one. I filed a second application which is pending.
Yes, what has happened to this application? It has not been considered till now.
After that, it came in once, but I mean, it was fixed for today after that. So, your lordship decides that now this has this Putu Bundan and Village Council is one, then I can withdraw my second application, which is for separation. Or if your lordship says no, make them a separate two different respondents, then my application is already there. But my lord, Village Council is a necessary party. Lordship has seen from their own conduct, my lord. Let us return in regards to the issue involved.
So that is one part. The second part is the main writ petition is pending.
One petition is pending, my lord.
Can it not be heard at one go?
Lordship, what will happen?
Decide these two.
Lordship,
and then go for the writ petition.
Subject to what my learned friend says.
Your lordship, I have no objection to the implement separating the Putu Bundan and Village Council as two separate respondents, your lordship. And in my respectful submission, subject to your lordship's satisfaction and what my learned friend says, your lordship, I think putting them in as separate respondent, that way an effective order can be passed, your lordship. Why I say so, your lordship? May I take your lordship to the writ petition? Page 14.
Okay.
Page 14.
Yes, the first title.
Yes, the Yongsonga Putu Bundan / Village Council represented by its chairman. Now, may I take your lordship to the IA 102 filed by the applicant, your lordship, 102 of 2026. Your lordship has got it?
Yes.
102, page 23. Para 6. Page 23. Lordship has got it? Now here, Yongsong Putu Bundan, Village Council Vice Chairman, whatever is there. This is what has been reproduced, which is the writ petition, para 7. Yongsong Putu Bundan represented by its aula. And para 8, and next page, your lordship, continue page 24, as response number 7, Yongsong Village Council represented by its chairman. Now, what I would like to impress upon your lordship is the Putu Bundan is not represented by chairman, it is represented by aula, and Village Council is represented by the chairman, your lordship. But here in the cause title, in the writ petition, only chairman is given. So Putu Bundan is represented by aula as in the IA, it has been rightly shown, your lordship. So in fact, if the effective order is to be passed to both the institution, your lordship, it will be, in my respectful submission, it will be better if the implement is allowed and then the matter will be fixed for taken up together for hearing along with the petition for deletion. On Monday, we can fix the date for hearing.
What is this aula?
Aula, he is the head of Putu Bundan. And Village Council is represented by chairman. So here in the writ petition, it is shown as represented by chairman. both Young Putumundan and village council, but Putumundan is never represented by chairman. Putumundan is represented by aula. So if this implement is allowed, and then we can take up the matter for your lordship will be here fixed for hearing Monday, along with the IA for deletion, that can be taken up together. My submission, subject to your lordship satisfaction.
Yes, what do you say?
Lordship, I'm open for my, IA can be taken out as a affidavit in opposition.
Yes,
Yes.
yes, my lord. Your lordship,
His IA can be treated as affidavit in opposition.
because he's already, the village council is already here before this honorable court. No notice will go. Lordship, if this can be, the village council will made a respondent number 7. And accordingly, I will order maybe honorable, this honorable court may pass an order to allowing me to amend the cost title. I'll file it, but, and hear it or not next, not possible.
Then
It's after the
then I leave it to him. Otherwise, from we are going.
No, there are some other matter.
It's up.
So lordship, if lordship, my application is 104, 102. As per 102, where's my application? Where's my application? Lordship, as per my application at page, as pointed out by the learned counsel, my lord, my prayer is that to allow me to make the necessary change in accordance with paragraph 7 of my application. So paragraph 7 is, my lord, the respondent number 1 will become the real son of Putumundan. Page 23, my lord. This will be just the real son, Putumundan respondent number 1, and respondent number 7 to become the village council, my lord. So new respondent, separating them into two different respondents.
Okay, then as per the original parties arrayed.
Yes, my lord.
Who will appear for who? At page 19 of your IA.
Who will appear? IA page 19, my lord.
Respondent number 1, who will be represented by whom?
Respondent number 1 will be Mr. TB Jamil.
Then
respondent number 7 will be represented by Learned Counsel Mr.
That is after separation.
After separation.
Before separation, who will appear?
I have to make the.
So we'll have to be doing that.
And number 2?
Number two, Mr. Jamil sir.
I am representing.
You are there number 2 already.
He is representing the Putumundan in the Sansumongta. That is our art.
Okay.
Now, what is it? Please,
Right, final.
Then what will happen to this other IA?
My IA.
What
becomes infractions, my lord.
No. If it becomes infractions, my affidavit will.
Oh,
no, that I will be treated as affidavit and written.
Okay.
Yes.
All right.
My stand will be the same thing, as I've already.
So, I 146 will be treated as an affidavit in the main case for respondent number 7.
In the main case, you have challenged these 4 orders.
Yes, my lord, 4 orders.
4 orders which you have reflected. Okay.
Yes, my lord, 4 orders.
And those are the crux of the matter where I've come in saying that I have not lost those orders.
Okay.
And I have nothing.
So then we'll dispose this 102 then.
Lost.
Mr.
Inti Longjam, my lord.
Inti Longjam.
Longjam, my lord, yes.
Inti Longjam, learned counsel for the applicant. This is 102, okay? Who submits that? Applicants, yes, applicants. Who submits that by filing this application, the applicants seek segregation of the original respondent number 1. That is the Young Jimson Sang, okay, it's difficult to pronounce. Okay, page 19, okay. Respondent number one, you have to reproduce that. As two separate entities, that is page 23, okay. Paragraph 7, respondent number one, and page 24, respondent number 7. So the learned counsel submits that separation of the respondent number one, the original respondent number one, as paid for, is necessary in view of the fact that
This is 146, 143.
the impugn orders, in view of the fact that
Paragraph 3 I've mentioned, Mother. Paragraph 3 I've. And formal of my application.
in view of the fact that the impugn orders in the main writ petition by which the applicants have been excommunicated have been passed by the respondent authorities acting sometimes as the village council and at times as Putumenden. So he submits that the village council concerned has also come up with an interlocutory application, that is IAC number 146 of 2025, for deletion of the village council as a rate respondent. So therefore, in order to resolve the controversy, for the purpose of considering the orders impugned in the main writ petition, the applicants may be allowed to segregate the two entities in the manner as prayed for in the application. Next para to the above submission of the learned counsel for the applicants. Mr. T.V. Jamil, learned counsel.
And for His Lordship here, and for Yongson Putumandan, response number 1. And my friend Apuk, he is for response number 1, but village council.
This statutory.
Appearing for
Yongson
Sangar Putumandan.
And
Mr.
Apok. Apok.
Mr. I. Apok Ponganar,
Yes.
learned counsel appearing for
village council.
the village council. Submit that they have no objection to the prayer. Stop. Additionally, Mr. Ponganar, learned counsel, submits that if the prayer is allowed, the interlocutory application number 146 of 2025 filed by the village council may be treated as the
Along with my rejoinder of authorization.
along with the rejoinder in the said application may be treated as the stand of the village council
Yes.
for considering the writ petition. Stop. Next para in view of
If you have the changes up to all those parties, liberty will be granted against them. To file an additional appeal.
state.
Yes. Make sure it is.
Okay. Mr. Tompo Ponganar.
No.
I'm sorry, Mr.
Imti-
Imchen.
Song.
Imtim Song, sorry. Mr. Imtim Song, learned additional AG.
Yes.
You appear for the state.
Yes.
And I don't think you have any objection. Any
They
objection?
filed the affidavit, my lord.
File additional appeal. Make sure it is.
Affidavit has already been filed.
In what? In what?
To the amended cost title.
Now, this council, separate.
Okay, Mr. Imtim Song, Mr. Imtim Song, learned additional advocate general, Nagaland, appearing for the state respondents. Also submit that if the prayer for segregation of the parties is allowed by this court, the state may be given liberty to file additional counter affidavit in the main writ petition. Correct? Next para, considering the submissions made by the learned counsels of the rival parties. The prayer for segregation of the original respondent number 1 in the manner as paid for by the applicant is hereby allowed. Stop. Further, the interlocutory application number 146 of 2025, along with the rejoinder affidavit filed by the village council, will also be considered as the counter affidavit of the village council in the main writ petition. Liberty is also granted to the state to file their additional affidavit, use advice in the main writ petition. Then the IAS has disposed of as allowed.
Yes.
In that case, additional order may be required to be passed in the.
In the main case.
In the main
The
rate.
main petition, Your Lord.
Yes.
Yes.
Then in the next, you write main writ petition. In view of the order passed today in IAC number 102 of 2026, the petitioner shall file the amended cost title in 2 sets before the registry of this court within 3 working days.
Lordship, a week, my lord.
Within a week. Okay, within a week from today. We'll stop. The amended cost title shall also be furnished to the learned counsels appearing for the respondents as well. Stop further. The stand of the respondent number one, isn't it? No, VC will be one now.
No,
VC will be seven.
Seven.
Okay.
Straight a correction.
Okay, after 30. Further, it is hereby provided that the provided that ISC number 146 of 2025, along with the rejoinder affidavit filed by the respondent number 7,
The village council.
village council, shall be treated as the stand of the village council. To stop the said respondents are also given liberty to file their additional counter affidavit on impeachment, on segregation of the parties concerned,
If so advised.
if so advised. List again when?
20th July, my lord, for the hearing of the case, that after the vacation.
Monday.
Yes, Monday, ma'am.
List on 20th of July 2026. In the hearing column?
Yes. Yes, my lord, in the hearing column. Yes.
Hearing column, that's paid for by the
I
parties.
don't.
Hearing one.
So the main dispute is regarding
Excommunication, my lord, social matter.
That is yes.
But the matter on excommunication has been dealt with.
Yes, my lord, it has been dealt with.
Cases.
It has been dealt with. It has been dealt with, ma'am.
So there's nothing.
Even the Supreme Court has similar cases are there. Okay. This is totally against Article 21, 19, and 14 also. They're called triangle, my lord, Trinity.
There's no customary issues to be settled otherwise, isn't it?
They're saying it's customary possible to excommunicate.
This is customary.
They're saying customarily it's possible to excommunicate, but the law is, my lord, laid down by this honorable court as well as the Supreme Court said, no custom can do that.
No, the reason why I'm asking is
Yes,
that
my
I think we already have some provision in the High Court rules
Yes.
that if any matter involves the customary law,
Yes, my lord.
it should be before a division bench,
All right.
and one of the judge has to be a local judge.
Oh, Lordship, that I was not aware, my lord.
That is there.
That's why you were not aware.
If that is.
That's why I asked, because excommunication has been dealt with.
Yes, it has been dealt with.
It was
Yes, it has been clearly dealt with.
Justice Manish.
Just one. Several.
The matter has been kept open.
Lordship, that has been dealt with since 1994. Similar
But then, of
cases.
course, they will come with the argument that division bench has said that it is kept open.
But, Lordship, that issue of excommunication has not been kept open. That is decided already, my lord. Whether Tata Salang is a village council or not, that something like that is kept open. Not regarding excommunication. Excommunication is certain.
What was the reason behind otherwise of this excommunication?
Lordship, we had
family dispute.
We had disobeyed them, my lord, regarding certain decision taken in regards to one a union in Chumukirima. We are staying in Chumukirima, my lord. Then we had formed a union, and the issue started that we said 1989 is the date of establishment. Every group said it is 2001, and the Putu and this village authorities got involved, and they said no, 2001, you take 2001, which we defied, my lord.
Okay.
And then this everything started.
Differences are there on that point.
Yeah.
And
Lordship, may kindly extend in interim order also, man. There's an
What is
interim
interim
order.
order?
Interim order.
What does it say, interim order?
This has been stated.
Okay, the interim order passed earlier shall continue till the next date of listing. See, in our parts, we have this kind of thing also, but it's not on this kind of differences. It's on something to do with, like crime or something, something done by the thing, and the person, the house is locked and excommunicated, has to leave the village like that.
locking up the house.
And your lordship,
Similar traditions.
as communication per se, lordship, we cannot be said to be violative of Article 1921. So long as the same rights, social and cultural rights have been granted under Article 25, 26, whatever. And more particularly when in addition to that, we have 371A, your lordship. That is also a constitutional guarantee, your lordship. this excommunication per se, your lordship, that will not be considered, no, it is violating Article 19.
I think it'll be a very interesting argument.
Yeah, your lordship in that, if your lordship must have come according to Maharashtra Excommunication Act, that was challenged, and constitutional bench held that no. That has been questioned, set aside.
In 2023, my lord, the earlier judgment has been deferred by the same strength, and it is now before the 9 judges bench, my lord, that case. Maharashtra case.
Okay. All right.
Obliged. Much obliged.
Obliged, my lord.
Orders, item number 29.
Yes, my lord. My lord, this IA is for implementing the Deputy Commissioner Mon district.
Okay.
Lordship,
As a respondent number,
5, Lordship.
why you want his impleadment?
Lordship, because as per the direction of the Honorable Court, as per the request from the government, they have for verification of the land owner between the petitioner and the respondent. In the state government affidavit, they have submitted a joint verification report. Joint verification report dated 11th of September 2025.
Okay.
That was forwarded on 12th September 2025, Lordship.
Anyway, you have objection to the prayer?
No objection.
No objection, isn't it? Heard Mr. Foseko Fote, learned counsel for the applicants who submits that by filing this application, the applicants seek impleadment of Deputy Commissioner Mon as party respondent number 5 in the main petition. He submits that impleadment of the said party is necessary for effective adjudication of the writ petition. Stop, Miss
Pichano for the state.
Ichano, learned government advocate, and Miss
Asindi Jamil for respondent number 5.
A. Jamil for respondent number 5. Submit that they have no objection.
No, 4. Should be respondent 4, Lordship. 5 is the newly implemented.
No.
Guardian
Cognac. You're for G Cognac.
I'm sorry. The 5, yes. I'm sorry.
Submit that they have no objection if the application is allowed as paid. Upon hearing the parties and upon perusal of the application for impleadment as paid for is hereby allowed. IA stands disposed of. Then in the main writ petition, you write, in view of the order passed today in IAC number 125 of 2026, the petitioner shall file the amended cost title.
Or should be memo parties, amended memo parties.
Amended cost title in 2 sets within
3 days, Lordship.
Within 3 days from today. Then
Lordship, here, while issuing notice to the Deputy Commissioner, Lordship, as per the OM, my lord, as per the notification dated 5th March 2018, that is at page 13 of my petition. Here, the report, joint verification report filed by the government should have been recommended. As per the joint verification report, the DC should have recommended based on the basis of the report, the DC, the Moon should have given a recommendation and should have referred with relevant documents to the Department of Land Revenue as to whether the petitioner or the respondent is the landowner. But here, without giving any recommendation or taking a decision basing on the joint verification report, the DC Mon has submitted to the PD, that is the Principal Director, Health and Family Welfare. So that is why he should be made a party. That's the reason. And here, my lord, my prayer is that if a direction will be given to the DC Mon to make a recommendation or take a decision basing on the joint evaluation report.
Notice has to go first.
Lordship.
DC is not yet completed by way of your amended cost item. We have to issue notice to him also.
Lordship.
Correct. Then you write issue notice to the newly pleaded respondent number 5. Miss so and so, learned government advocate, accepts notice. You can accept
Lordship.
the notice on behalf of respondent number 5. Extra copy of the writ petition be furnished to
Lordship.
By the petitioner within a week.
Lordship. Lordship, if the matter can come up next week, Lordship.
Within 3 days. Not week, within 3 days.
I'll furnish the copies within 3 days, yes, Lordship.
But she'll have to get instructions also, isn't it?
Lordship.
Let's get Lordship after vacation, maybe.
List again. On so we on a vacation.
No, Lordship.
List again after the ensuing summer vacation.
I read 13, 14.
In the meantime, respondent number 5 to file the counter affidavit. No matter. All right.
I replies, Malas.
Any more? That's all. Yeah.
Itu rural concession. Rural concession.